Florence Weaver and Dave Boston. Oh, what are we doing? You running that? What's going on with Dane Austin? Is Toby running it?
Yeah, he was. He was speaking from what he told me. It'd be a possibility.
Okay, but we don't have an update. Okay. What about Armand Gibbons? Is Armand Gibbons here?
He's on that one as well. That would be mentioned. They possibly be a right.
Is Gibbons here?
I haven't seen it.
Givens, he has been here. Right in the
Is he in the hallway?
Oh, you know what? Apologize. Let's right. Oh, Gibbons?
He is here.
Yeah, he's here.
Okay, but his attorney is not?
No.
Okay. There's not a seat for him in here, so he can stay up there. State of Michigan versus Damon Hemphill, 25-03845, appearance.
Ross Marchman on behalf of the people.
Edward Christensen on behalf of the defendant, number 5/192.
Okay, this is a preliminary examination for carrying concealed weapon, possession of analog weapons. How are we proceeding on this?
Your Honor, it's people's understanding that both parties intend to unconditionally waive the preliminary examination. The people have made an offer in which the defendant will plead guilty to count 1 and agree to forfeit the firearm at issue here in exchange for dismissal of counts 2 and 3.
That's correct, counsel.
That's my understanding of the plea, Your Honor, and we are moving today.
Okay, Mr. Hemphill, you understand your right to have a preliminary examination on this matter on each of the felony charges?
Yes, ma'am.
And you're willing to waive your right to have the prosecution establish that they have sufficient probable cause that a felony was committed and then sufficient probable cause to charge you as the person who committed the felony? Is anyone promising you anything not stated on the record to get you to waive your exam? Any threats to get you to waive your exam? Combined over date is going to be July 1st. That's the date the circuit court's receiving the file from the district court, not a court date for you, okay? Your next court date will be a pretrial in the circuit court. Your attorney will be made aware of that. Do you have any questions at this time?
No, ma'am.
What's your address?
17571 Ardmore.
In Detroit?
Yes, ma'am.
Phone number?
136528250.
Any changes to your address or phone number requires you to make notification to the court in writing, okay? A bond is set. Goes into the file. The bond will continue as set, as well as bond conditions, any additional matters for the record.
Nothing for people.
No, Your Honor.
We're all set, thank you.
Thank you, Your Honor.
Mr. Gibbons can come in here now. State of Michigan versus Carol McIntyre, 20-02130, appearance, please.
Ross Marchman on behalf of the people. Lead Aaron Schroeder represents Ms. McIntyre.
Oh, the shoulders.
I am.
Appearance for the record.
Ross Marchman here for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Ms. McIntyre. Ms. McIntyre is not here. She did reach out to my office this morning indicating that she had the flu and that is why she was not here and trying to get documentation.
She has the flu.
That is what she indicated in the voicemail she left at my office.
I'm looking at an email requesting from you to treat today as a PCC.
That was something that we were going back about yesterday, myself and the prosecutor. I had not heard back from
2020 case. Is there an offer?
Yes, Your Honor, the people had extended a misdemeanor offer in which the defendant was plead guilty to OWI second offense with dismissal of the balance.
And I had relayed that to Ms. McIntyre and we were working through that.
She ironically has the flu today. Last time she failed to appear, that was a big excuse, she was ill.
Your Honor, if I may, respectfully, I believe, and it has been some time, there was a death or pending. Her significant other was ill and she was in the hospital with him. I did provide documentation, but
She was ill?
no, she was with her significant other.
No, that's not what she said. She said she was ill.
At the last time.
Yeah.
I apologize, Your Honor.
You can't keep using that as an excuse. It's a 2020 case. I'll give you a date, please. July 9th at 9:30. July 9th at 9:30. Matters for the record.
Nothing from the people.
That was July 9th at what time?
9:30.
9:30, and is that going to be a preliminary exam or pieces?
Preliminary examination.
Thank you. Nothing further.
I'm not to sign her probation orders. I don't know what probation stuff is.
I got you.
State of Michigan versus Robert Nick, 26-01434. Appearance, please.
Ross Marshall.
Public Defender John Lee on behalf of Robert Nick.
Mr. Nick was given an offer for misdemeanor plea and alluded to accepting that offer.
My understanding that he is accepting this offer. Now none of the people are amending it from the motor vehicle code to the criminal code in order to make him kind of eligible.
To approach, Your Honor.
Yes, thank you. Plead guilty to the amended count 1 of attempted plea and allude, is that correct?
Yes.
Raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Speak up with your hand down. This is an advice of rights and plea information sheet here. Is that your signature?
Yes, ma'am.
And you went over these rights with your attorney?
Yes, ma'am.
You understand all of these rights and you're willing to give these rights up today? Okay, so that means that you are going to waive or give up your right to the presumption that you are innocent until proven guilty. You have the right to maintain your innocence and require that the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to see, hear, or question under the confrontation clause any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf, the right to remain silent and not have silence used against you, or you can waive silence and give testimony at your trial if you like. Do you understand those rights?
Yes, ma'am.
Anyone threatening you to give these rights away?
No.
Are you on probation or on parole? You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer, or you may need to give report that on a future job application. It also could have impact on where you can travel or get immigration status. Do you understand that?
Yes, ma'am.
As to the amended count of an attempted plea in lieu, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Nick, on or about May 26th of 2026, were you at the location of Christensen Road and Rio Road?
Yes, sir.
And that's in Lansing, Michigan,
Yes, sir.
in the county of Union. And at that time, you were riding a mini bike, correct?
Yes, sir.
And you encountered Lansing police officers.
Yes, sir.
And you encountered them because they pulled up behind you in their squad car, correct?
Yes, sir.
And they initiated their sirens.
Yes, sir.
And your understanding was that they wanted you to pull over,
Yes, sir.
but that's not what you did.
Yes, sir.
You accelerated and fled from them, correct?
Yes, sir.
No further questions.
People are satisfied with the factual basis, Your Honor.
The court is satisfied with the factual basis of accept your plea. Find your plea to be freely, voluntarily, and intelligently made. What's your phone number?
Oh, mine.
Correct.
I got a new one. I don't know if I.
Yeah, you said that on the 28th. I need your phone number today.
Am I able to pull my phone up?
Yes. I don't know why people this week don't remember their phone numbers. I recognize we're in a position in society where we don't remember other people's numbers, but it's like basic that you remember your address and your phone number. I don't care if you got a new number or not. If you saw somebody that you were interested in and you wanted to give them your number, you'd figure it out, wouldn't you?
Yes, sir.
Be interested.
Five one seven 326 2291.
2291.
Yes, ma'am.
Okay. Matter is scheduled for sentencing August 6th at 9 a.m. You'll go downstairs 1 floor when you leave here. Checking with probation. They're going to prepare a pre-sentence interview. So they're going to schedule you for that. There's paperwork that you'll fill out today. You need to report back to them so that you can have the pre-sentence interview done. Do you understand that?
Yes, ma'am.
You do not want to come to me on August 6th and I do not have a pre-sentence report completed because you failed to comply. Do you know what could likely happen if you do that? What would happen? You're going to jail. So you need to comply with the court order. Your attorney don't need to come here and ask me to put you on probation if you can't comply with orders already. You understand that? Okay, so you go down, check it with them. They'll get you scheduled, they'll get you paperwork, you'll complete that, and then you'll follow up with them for the interview. They'll give me a report. You may appear for your sentencing via Zoom, okay? Any additional matters for the record?
Nothing from the people.
Nothing for the defense, thank you.
Thank you. Calvin Williams is downstairs.
Yeah,
He can be brought up.
okay.
State of Michigan versus Armand Givens, 26-00265. Parents, please.
Ross Marchina for the people.
Morning, I'm Wayne Silverthorne. I'm filling in for Melanie Wadji, and I'm from the Public Defender's Office on behalf of Armand Givens, who is standing to my left, accountable.
Mr. Givens has a weapons felony, firearms larceny, and a carrying concealed weapon. How are we proceeding today?
Your Honor, it's people's understanding that both sides intend to unconditionally waive the preliminary examination. I believe we placed an offer on the record last week in which Mr. Givens would plead guilty to either count with dismissal of the other, and the people would not object to the defense's petition for guidance.
Is that correct, Mr. Givens?
That is correct, Your Honor.
Okay, and then Mr. Givens, you do understand your right to have a preliminary examination in this matter?
Yes, ma'am. I do.
And you understand the purpose of the examination? You have the right to require that the prosecutor establish that they have sufficient enough probable cause that a felony was committed and then sufficient probable cause to charge you as the individual who committed the felony. You understand that? You want to waive your exam. Anyone threatening you to do that? Any promises not stated on the record to get you to do that? Anyone promising you anything to get you to waive your exam? Oh.
Yeah.
Thank you. I find your waiver to be freely and voluntarily made. I will be bound over for a date of July 1st. That's the date the circuit court is receiving this district court file, not a court date for you, okay? Okay. The next court date will be a pre-trial and circuit court. Your attorney will be made aware of that, okay? Have any questions at this time?
No, ma'am.
What's your address?
I live with my TT now. I was 35. Thanks for that.
You don't know that?
I live with my TT now. I just started.
Can you speak up, please?
I just started living with my TT.
What's a TT?
My auntie.
Thank you.
Sorry.
Okay. And when did you just start living there?
Like a month ago, 2 months ago.
Okay. And how old are you?
I'm 19.
So at 19, you can live someplace for 30 days and don't remember the address.
Sorry. I'm sorry.
I just want you to all understand that you should know your address and your phone number. That's basic information. When I was growing up, we had to learn it in kindergarten. We knew where we lived. If you get lost. What's your phone number?
517-328-8282.
8282? Did your phone number change?
Oh, I'm so sorry. It's 517-328-8282.
Okay, did it change? That's not the address that the magistrate wrote down at the time of your arraignment. Did you change your phone number?
Oh, yes, ma'am.
Okay. It's your responsibility if there's a change in your phone number or address to notify the court in writing. That's part of your bond condition. You understand that? Okay. So you are reporting to pretrial services. If there's a change, you have to notify them, okay? Do you have any questions? Okay, you're gonna work on remembering your address and your phone number. You're going to stay in communication with your attorney, who Mr. Silverman is just filling in, correct?
That's what's that.
Okay, it's Ms. Wanji. Bond will continue. Any additional matters for the record?
Nothing from the people.
Nothing from this point. Thank you, Your Honor.
Wonderful. Okay, and then what are we doing with Alston, Mr. Silverman?
I think he's gonna enter a plea to B&E a motor vehicle.
Hardy here?
Yes, he's out hall. He said he's ready.
Okay, he can come in.
Yeah. You'll get.
Is the probationer speaking? Don't say please. I have to do this just to write
Oh,
on
that's me, Judge. I apologize. That was me.
this paper.
I got you.
Okay, State of Michigan versus Caitlin Bosma, 26-00722.
Ross Marshall for the people.
Assistant Public Defender Joseph Hardy, on behalf of Ms. Bosma, filling in for Attorney Dick Crowley. According to my notes, there was a attempt to reach Ms. Bosma yesterday. She let us know that she was having issues being arrived today. As of right now, I'm able to make contact this morning and do not see her in the hallway or
I'm so very confused because she can appear via Zoom for sentencing. Why is she not here?
do not have that information for you.
Okay, well, I'll show you. Sure. Jacob's iPhone. Mr. Rowley, maybe? No? Wilson. Oh, okay. See, Mr. Goodrich. State of Michigan versus Taylor Little, 26-00890.
Ross Marshall for the people.
Aaron Robinson, Assistant Public Defender for Ms. Little, who's walking up to the front right now.
Okay, Ms. Little was scheduled today for preliminary examination on assault with intention to great bodily harm, less than murder. How we proceed?
Your Honor, the people are going to need to nolly this case due to the non-appearance of a necessary witness.
There's no objection to that.
Correct, no objection.
We'll get you a copy of dismissal in just a moment. The people have the right to reissue this against you. Do you understand?
Yes.
Do you have any questions, ma'am?
No.
Well, we're all set for today. State of Michigan versus Clay Sean Jones, 26-01299, 26-01437.
Ross Marshall for the people on both files.
Attorney Luke Goodrich from Public Defender's Office to represent Mr. Jones on both files as well.
Mr. Jones has an armed robbery and a weapons charge, and then a carrying concealed weapon in the other file. How we proceed today?
Your Honor, Mr. Jones would like to waive his exam on the CCW case. However, I believe Mr. Marshall would like to run the exam on the armed robbery.
That is correct, Your Honor. The people would like to unconditionally waive the preliminary exam on the CCW. There's no offer placed on the record at this time, but I anticipate there will be offers in the circuit court on that file. And the people do wish to conduct the examination in the armed robbery.
Counsel, you can approach. And we have our necessary witnesses here for the other matter.
Yes, Your Honor.
Okay, you can remain standing, Mr. Jones. As it relates to the carrying concealed weapon in 26-01437, you have the right to a preliminary examination. You have the right to require the prosecutor first establish if they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony. You understand that? And are you willing to unconditionally waive that exam? Any promises to get you to do that? Anyone promising you anything to get you to waive your exam? Anyone threatening you to get you to waive it? The bind over date on that file is going to be July 1st. That's the date the circuit court will receive the district court file, okay? Not a court date for you. You have any questions on this file? Your bond is set at 10,000, 10%. That will continue. Any other matters on this file?
Nothing for the people on this file.
Nothing for the defense, Your Honor.
Okay, you can have a seat until we're ready to do the exam on the other.
At that council table, do you want to, or you do
Oh,
some matters?
down there, because I think I just brought somebody up, so we're gonna handle some other matters.
Go ahead.
Thank you. Who is this?
Calvin Williams.
Okay, State of Michigan versus Calvin Williams, 26-01371, 26-01372. Appearances, please.
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Jacob Rowley for Calvin Williams, who is in the courtroom and standing to my right.
Okay, both of these files contain 3 counts of failure to pay child support. My understanding is that the parties are going to enter an unconditional waiver. Is that accurate?
That's correct, Your Honor.
Ms. Williams, is that accurate?
That is correct, Your Honor.
Was there an offer at this time, or negotiations continue at circuit court?
Yes, Your Honor, I did submit an offer on both files by email, via email, last week, I believe.
You received that, Mr. Lee?
I believe you did.
Who did you submit it to Mr. Raleigh or?
To Mr. Raleigh, explaining that Ms. Brenner and I had switched counties. I sent it to him the evening before the PCC, and I think that he was out the next day. And then I learned that I think a few days later, the preliminary exam would be waived. But I did email it to you.
Are you aware of your offer, sir?
Yeah, I spoke with my.
You know what your offer is. Please state the offer for the record, please.
Yes, Your Honor. If in file 26-01371-FY, the arrears at that time was $34,547.77, likely to still be true because it's June, the month has not ended. If he pays his arrears down to $25,947 by the time of plea and pleads guilty to counts 1 and 2, we will dismiss count 3 and recommend a delay of sentence. If during the delay he pays monthly and pays the arrears down by half, $17,200, he will earn a single count of an attempt. Counts 1 and 2 would then be dismissed. And if he pays the arrears in full to a 0 balance, he will earn a single count of a misdemeanor disorderly. Or in the alternative, he can plead to counts 1 and 2, and we will dismiss count 3. In file 26-03172-FY, he owes $5,872.54. If he pays these down to $4,400 and pleads to counts 1 and 2, pays as ordered, we will dismiss count 3 and recommend a delay of sentence. If during the delay he pays the arrears down to $2,900, he will earn a single count of an attempt. Failure to pay, counts 1 and 2 would be dismissed. And if he pays the arrears in full to a 0 balance, he will earn a misdemeanor disorderly. Or in the alternative, he can plead to counts 1 and 2, and we will dismiss count 3.
Okay, Mr. Lee, you can approach for the paperwork. Mr. Williams, you understand that you have the right to have a preliminary examination on each of these files? You understand that the purpose of the exam is so that the prosecution would have to first establish probable cause that felonies were committed, and then probable cause sufficient enough to charge you with each count of the felony. And you wish to unconditionally waive your exam? What part is confusing you? The unconditional part?
Yeah.
That just means there's no condition, no one's promising you anything to get you to do it.
Okay,
You understand that? Is that what you want to do?
yes.
Okay. Apparently they have to order some special things if it's on. Because the building from. The building's real, bro. I don't know if we're gonna make it. It's like piece by piece. Yeah, I think we're school meeting, it's a phone now. Probation is funny. I heard, no, we're not gonna make it. They waited to the last possible straw. And the building was like, we're done. It's been on its last leg now. It's like. Wait till, you just wait till it turns 30 degrees. I'm like, no. The balloons are popping and floating. So like pop, 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 done. Okay.
I want to sit down. You're not my lord. Who are you? So they won't negotiate on Monday? This judge came from my circuit court. I don't believe you. Just trying to say. So. So do I get a copy of this?
Okay. Let's see. About, again, the bind over date on both files will be July 1st.
Okay,
That's the date the circuit court's going to receive the district court file, not a court date for you. Okay, sir?
okay, so I should have a court date next month though?
Once they receive it, they'll set it for a pretrial date. I can't say with certainty that it'll be next month because I don't know what their docket looks like.
Right.
So because they're gonna receive it on the first, it's reasonable to think that you might get a pretrial.
Okay,
But your attorney should be in contact with you, and you remain in contact with him, okay?
I will.
Do you have any questions for the court at this time?
Nope. Thank you.
Give me just a moment. I have not yet released you. Okay, file number ending in 372, bond was set $1,390 cash only. Bond ending in 7/1. Bond is set at $8,277 cash only. Both will continue, as well as a no contact order between you and an Autumn Behrens and then Samantha Joe Dokum. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing to the defense. Thank you.
Thank you. Now you're all set.
Thank you.
Thank you.
That Dane Austin.
Dane Austin. Okay. This is the state of Michigan versus Dane Lamond Alston, 26-01433. Appearance, please.
Ross March, speaking up for people.
Good morning, Your Honor. Dwayne Silverthorne filling in for Melanie Wadley, up the Office of Public Defender, and it's on behalf of Dane Alston, who is standing to my right at council table.
Mr. Alston was scheduled for a preliminary examination on a motor vehicle larceny. How are we proceeding?
Your Honor, the people have offered for an amended count of breaking and entering a motor vehicle with intent to steal less than $200, 93-day misdemeanor, and it's my understanding the defendant wishes to accept this offer.
That is correct, Your Honor. If I may approach.
You may. Thank you.
You're welcome, Your Honor.
Mr. Alston, that's how you want to proceed?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. I do have an advice and rights and plea information sheet that's dated for today. Is that your signature? Okay, and you went over these rights with your attorney, correct?
I did.
Do you have any questions about those rights?
No, I don't.
You understand that you have the right in that matter or this matter to proceed to preliminary examination. The right to require them establish probable cause that a felony was committed and probable cause that you committed the felony. You also have the right to proceed to trial and maintain your innocence and require that they then prove each element of the charge of larceny beyond a reasonable doubt. Do you understand that? Are you willing to waive those rights and your presumption of innocence?
Yes.
Okay, and that means you're gonna give up your right to question or cross-examine in court any witness that's called to testify against you, the right to remain silent and not have it used against you, and the right to subpoena witnesses to testify on your behalf. You understand that? Is anyone threatening you to plead guilty?
No.
Any promises to get you to plead guilty?
No, ma'am.
Are you on probation or on parole?
Well,
Okay, you understand that this could trigger a parole violation.
yes, ma'am.
You also understand that this could result in conviction that you may need to report to your current or future employer. It also could have impact on where you can travel or get immigration status.
Yes, ma'am.
And are you pleading guilty because you believe you are guilty?
Yes, ma'am.
As to the amended count of breaking and entering a motor vehicle to steal less than $200, how do you plead?
Guilty.
Factual basis, please.
Yes, Your Honor. Mr. Alston, I'll take you back to on about May 27th of this year. Were you at 616 Bartlett Street?
Yes, sir.
Is that in the city of Lansing, state of Michigan?
Yes, sir.
And at that time, did you enter a green Jeep SUV?
Yes, sir.
Okay, were you the owner of that
No, sir.
vehicle? Did you have any permission to enter that vehicle?
No, sir.
Did you, to obtain entrance, did you need to open the door and go into the vehicle?
No permission, sir.
You had no permission. I believe that's a factual basis, Your Honor.
And did you have intent to steal property when you entered the motor vehicle?
No, sir.
You were rifling around with items in the vehicle, is that correct?
Yes, sir.
Okay. When the police found you, there were items that had been clearly moved around in the vehicle, correct?
Yes, sir.
With intent to steal.
Yes. Yes, ma'am.
You don't have to say it if it's not the
Yes,
truth.
ma'am.
You said it's true?
Yes, ma'am.
Oh. Any other factual basis?
No, Your Honor, the court is satisfied. Thank you.
The court says on the factual basis, I'll accept your plea. I find the plea to be voluntarily and intelligently made. It's not scheduled for sentencing August 6th at 9 a.m. Yeah, does he have a parole hold already?
He has a parole hold and he's serving it now. I was gonna ask if the court would reduce his bond to a PR bond, given that this is 92-day maximum, and given that he still has to serve whatever his agent in full, Hearn, determined that she's going to impose under her. I guess she has administrative powers given by the parole board. And he is serving that now. And he realizes that even with the bonds, he will remain there until she gets released. But at least if and when she releases him, he could then go.
What is he serving for his parole violation?
The underlying offense was.
Yeah, has he been sentenced? You said for parole?
He has an administrative violation and punishment that has been imposed by Ms. Hearn. The process would be then she would make a recommendation to the parole board. So he still has that pending.
Okay, so parole board hasn't made a determination.
I believe it has not.
So what are we releasing him to?
Well, she has the authority apparently to release him, have him go back to all the fact. He's signed up to go to a Michigan Department of Corrections program. This is holding its offender success program eligibility screening form. It's filled out and actually it's been signed by Ms. Hearns. And that's what he would like to do.
This program is where? In custody or out of custody?
I believe that it's out. I have the form, like, to lose it briefly,
Yes, please.
if I may approach. Your Honor, as you're reading that, I was informed by Mr. Alston that it's a program in Flint known as Sacred House to rehab.
So you want me to PR him so that he can go potentially to this program? We don't know if he's going to be approved by the parole board to have the hold release.
He's whispering there that he has been already approved, but I have no verification right now. And yes, your characterization would be absolutely correct.
Okay, well, if you provide me the verification, then I'll amend the bond. Until then, the bond will remain as is. Any additional matters for the record?
Nothing for the people.
Your Honor, would verification be sufficient if I were to contact Ms. Nicole Hearn, his parole agent, and have her notify the court?
Absolutely.
Okay, thank you very much.
Thank you. To bring up, Ms. Donadio, your client is here via Zoom.
Mr. Wilson's on Zoom, Judge, and Mr. Porter's on holding, I believe.
in quarter.
Waiting for, and what's going on with Wilson?
I'm asking for an adjournment to get body cam. I spoke to the prosecutor. We need a few weeks on it. And I'll review the body cam, see if we want to run it.
Jaden Dodge is downstairs.
Yeah, Hardy's on that.
Huh?
Hardy's standing on that.
It's the state of Michigan versus Jacob Wilson, 26-01238. Appearance, please.
Ross Marshmead on behalf of the people.
Good morning, Honor. William Amadeo, P761 micro, Mr. Wilson, who is on Zoom. Mr. Wilson, please state your name for court.
Mr. Wilson, can you hear us?
Yes,
Okay, what's on your head? Why do you have a stock?
it's a
Why do you have a
hijab.
stock? Yeah.
Religion,
Excuse me?
religion,
Excuse me?
religion.
I didn't ask you what it was.
It's a hijab.
Stock.
The job, I think he said.
That's what he said. That's not what I saw.
Mr. Wilson, could you please take that off while you're in court?
Okay. How are we proceeding on this?
Your Honor, I need some body and dash cam. I did speak with my client a few times. I definitely want to review the body and dash cam before I make any decision. We'll waive all statutory timeframes. I did speak to the people about this. I don't know how long it will take them to get it. I guess at least a couple of weeks.
Since our conversation, it does appear as though 11 videos were conveyed a couple weeks ago. So I will need to figure out exactly what it is he's looking for.
I got a little paper discovery, Your Honor. I didn't get videos. I'll check my spam. Sometimes that happens, but I didn't get any videos at this point that I'm aware of.
So your client's gonna waive the 21 days?
Yes, Your Honor.
Okay, so Mr. Wilson, you have the right to have your examination within 21 days of the date that you're arraigned. Due to your attorney's request for additional discovery, are you waiving that timeline so this can be reset?
Yes,
Okay.
July 16th at 9:30.
July 16th at 9:30 work for you, Ms. Amadeo?
Yes, thank you, Judge.
Okay, we'll have an in-person examination date scheduled for that date and time. Any additional matters for the record?
I just note that we figured out the issue. It was sent to Mr. Amadeo's old email address, so we'll get that corrected.
That's correct, Judge.
Sounds good, but it sounds like it's a lot of video anyway, so.
Yeah. Thank you.
Any additional matters on this file?
Nothing, Your Honor. Thank you.
Thank you. You're all set for today, Mr. Wilson.
all right, thank you.
You're welcome. Okay, what's the code of the case? That's Porter and Simpson? Yes. Porter and Simpson. Are all of them waivers or just two? Just the Porters. Okay, and then we're running Simpson? We did one for glacier. Not that one. Okay, Quarters can be brought up. What are we doing with Christopher Ford?
Your Honor, my understanding is that people have witnesses here, they would be prepared to proceed. However, speaking with Mr. Ford, he wishes to request an adjournment.
On the record in the matter of the people of the state of Michigan versus Christopher Ford, 23-01253.
Your Honor, he's out in the hallway. I'll just.
One. This is Christopher Ford.
Yes, ma'am.
Okay, this is scheduled today for carrying concealed weapons, possession by felon, firearms and felon firearm, second habitual. My understanding is you're ready to proceed.
Yes, Your Honor, the people are ready to proceed to the preliminary examination.
Okay, this was previously adjourned because there were going to be some federal prosecution. That's not happening. Or it has not
That is
happened.
correct, there.
Okay, got it. So you're just
I
ready to
think
move
it's
forward.
not happening. Mr. Austin indicated to me, all the discovery that we have has been conveyed. There are 9 files on evidence.com that were shared back in March. We have 2 witnesses here. We do have a certified judgment of sentence available for the PIP charge. We are ready to proceed to examine.
Thank you, Your Honor. Some procedural history on this. This matter has been adjourned out when Mr. Ford was represented by previous counsel in our office with, I think, maybe the expectation that maybe the federal government would be pursuing prosecution in this case. I reached out to Mr. Marsmita earlier this week to see the status on that. And that was confirmed yesterday afternoon that they would not be taking the case and therefore would be proceeding. The case was reassigned to me towards the end of last month. From speaking with Mr. Ford, he wishes for me to ask an adjournment. He has not yet had the opportunity, or well, I don't want to misspeak. I think he would have perhaps had the opportunity with previous counsel to have received or reviewed the various evidence.com materials. But I think if I understand correctly, is that he was expecting the defense to take over the case. And that is why that did not occur with his previous counsel. He would wish to have an adjournment so that he can review that and more thoroughly discuss it with me in preparation for the
This is
preliminary hearing.
2026. This is a 2023 case. All the adjournments that were going to happen in this court have happened. We're proceeding today.
If that is the case, Your Honor, then I would be prepared to proceed with the hearing.
Thank you. How many witnesses do you have?
2.
2 witnesses. Okay, we can have a seat. We're bringing up a waiver and then we'll run this one.
Thank you, Judge.
How many witnesses are in place, Sean Jones?
Just 1.
1. Lamarcus McAbee here?
Yeah.
The state of Michigan versus Lamarcus McAbee, 26-00090.
Ross Marchina, the people.
Okay, Mr. McAbee is scheduled to sentencing today on controlled substance use. We have a pre-sentence report that was prepared on the 15th. You got a copy of that, counsel?
I do.
And reasons to make corrections, updates, or deletions.
No, everything's correct.
Nothing from the people.
We can make that a motion.
Thank you, Your Honor. Mr. McAfee, I've known him for a period of time. Judge, he's collecting the Social Security because of a learning disability. At this point, it's been tough for him to make any money. He had indicated to the probation department that he felt, at least when he talked to me, that if he was placed on probation.
Can you speak up, please?
If he was placed on probation, it would set him up to fail. And so he doesn't.
Probation would set him up to fail.
Well, no, she couldn't. I guess the idea is that if we put him on probation, I'm concerned, based on his conversation with him, that he would violate probation.
Yeah, that's not probation's fault. That's
No, I
his
didn't
fault.
find it.
He
You
just,
know,
what he's
Judge,
saying, that's all I hear. I don't want to be compliant. I want to do what I want to do.
No, I don't think it's that, Judge. It really isn't that. He is just having a tough time in his life. He hasn't been able to get employment. He wants to leave the state of Michigan and try to find employment somewhere else. His life's in kind of in a turmoil right now, Judge, and things aren't going well. But based upon the nature of this particular offense, it came down to a misdemeanor. They're recommending 7 days in jail, but we would let the court. We'd indicate the court whatever they would like to do with Mr. McAfee.
Mr. McAfee, what makes you believe that you are unable to comply with probation? Because again, this was a plea to a misdemeanor controlled substance use, which is punishable up to 1 year. I can guarantee you, I'm giving you more than 7 days in jail. Explain yourself.
Speak up to the judge.
Yeah, I just feel like if I'm doing probation.
I can't hear you.
I feel like if I'm doing probation, it is set up, you know what I'm saying, to go back to prison. I ain't trying to go back to prison. So
Probation can't set you up to go to prison. Did your attorney tell you that?
Nah,
Yeah, this is not a prison, the maximum penalty is not even prison, it's jail. There's a difference. You do know that, correct? Because you've been to prison.
right.
Okay, this is jail. The other issue is that probation is not set up to push you in prison. Probation is set up for you to have some restrictions and some guidance and some structure. And what you don't want to do is comply. If you don't comply, then you go to jail. That's the only reason when you go to jail on probation is because you fail to comply with the requirements. You want to live your life and do what you want to do. That's why I have a 20-page criminal history for you. Because you want to do what you want to do. You're going to do 1 year of jail or 1 year of probation. Take your pick. Thank you.
Thank you. No, thank you, Judge.
Okay, while on probation, you have the following conditions. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance. You understand that? You're not to engage in any assaultive or threatening behavior. You will be required to submit to random preliminary breath testing and urinalysis testing. You got to pay the cost of that. You'll figure it out. The same way you can figure out how to get money to buy the substance that you were using, you will now figure out how to get the money to pay for testing. You understand that?
Yes.
Okay. You're not to be in any bars or any nightclubs. You're going to enroll in treatment and provide evidence that you're in treatment. How far did you get in school? You're going to enroll in a GED program. And you're going to provide evidence that you're enrolled in a GED program. That's the only thing that I will allow you to do in lieu of working a full-time job. If you show me you're in school, then we'll have to waive your job requirement, okay?
Yes.
But you got to be in one or the other. You're not just going to be sitting around with plaits in your hair all summer kicking it. You're going to do something productive. You're 40-something years old. It's time to grow up. It's time to take responsibility and accountability for your actions and not blame it on the system that you keep putting yourself in jail or in prison. You give us no choice when you commit the actions I see on your criminal history. We don't have a choice, but we give you a chance to try to show us something else. It requires you to put in the effort to do what's right. It first starts with the decision that I'm going to do what is right. You tell yourself that. You profess it over yourself. I'm going to start doing what's right. You understand that? That's not difficult. It's not difficult to do what's right. Just do it. Okay? Okay, so you're gonna provide evidence that you are enrolled in a high school earning or GED program, or that you have obtained employment. You're gonna provide evidence of that. And then also, again, you're gonna get enrolled in outpatient treatment and provide evidence of that. Do you understand that?
Yes, ma'am.
You're gonna check in with your probation officer before you leave here today. You'll be meeting with him. Let me make sure it's in here before I say that. You'll be meeting with, yes, Mr. Sumter. You'll be meeting with him monthly. Do you understand that?
Yes, ma'am.
And so you will do that, or you'll spend 365 days in jail. Credit 1 day. You only get credit for 1 day. That means you'll have 364 days remaining, and you don't want to do that, do you? Okay, let's see here. It's a $30 per month oversight fee for each month of probation you're responsible for. So for 12 months, that's $360, give you $75 crime victim rights fee plus $50 state minimum cost. That will all be assessed. However, you prioritize paying for your testing right now until you get a job. And then we can talk about these other fines and how we'll get those paid, okay? The total fines will cost $485. This is an advice of rights and plea information sheet. I'm sorry, this is advice of rights as it relates to probation. You have the right to request early discharge from probation once you complete half of what I just ordered you to complete. 6 months in, you have been doing your GED program and or finish it. 6 months in, you have a job and I've gotten no violations within 90 days preceding any request. You can now request to be discharged early. You understand that?
Yes, ma'am.
You would make the request by getting the form from Mr. Sumter, or you can go on the court website and use the court's MC 512 form. You would complete that form. You have to give a copy of it to the prosecutor and a copy of it to probation. If they want to object, they have to file an objection in writing within 14 days. If I set it for hearing, you have the right to hire an attorney to represent you or beg Mr. Blackman to represent you for free. You do not have the right to court-appointed counsel. Do you understand?
Yes, ma'am.
Do you have any questions about how you can request early discharge? Any additional matters for the?
I have nothing, Aaron. Thank you very much.
Best wishes.
Nothing from the people.
Thank you. We gotta get it down to check in. with
I
you.
will make sure.
Thank you.
Fred, I gotta follow you with the file.
I think.
He's gonna follow you with the file.
Okay, all right.
That's right.
Oh,
Oh, I couldn't see it.
Yeah, I'm sorry.
Okay, which border is that? This which one?
This is the manual.
Okay, State of Michigan versus Emmanuel Porter, 26-01440.
Good morning, Your Honor. Natalie Macomber on behalf of the people.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Emmanuel Porter. He stands present and to my right.
Okay, Mr. Emmanuel Porter. Okay, Mr. Porter was scheduled today for a preliminary examination for armed robbery and carjacking. My understanding is that there will be an unconditional waiver.
That is correct, Your Honor. Not only on 2 charges, but on an added 2 counts of felony firearm.
That's correct, Mr. Austin.
One moment, Your Honor.
Yes, Your Honor.
Did you know that? You didn't know that? Okay, well then I can't accept the waiver. You didn't even know that. I could go off the record so you can counsel.
Sure.
Maybe you want to go over there, back in the jury box.
That would be.
Is Mr. Perone here?
His client's in that wheelchair.
Okay, maybe they stepped out. Is Mr. Perone out there? Do you know?
He did poke his head in.
I know his client, I think, was in a wheelchair, so maybe that's why they stepped out. Is Mr. Perone out there?
Yes, he's out there with his client.
Are they ready?
Let me double check.
This is the state of Michigan versus Charmaine Giles, 26-00543. Can I have your appearances, please?
Thank you, Your Honor. Randall Berman on behalf of the people. Jacob Perone on behalf of Charmaine Giles, who's present in the courtroom to my right.
Okay, Mr. Giles has a delivery, manufacturing of drugs, possession by prohibited person, 2 counts, controlled substance, drug counts, and 3 found firearms. My understanding is there's an unconditional waiver today.
That is correct, Your Honor. That is correct, Your Honor. Both parties were unconditionally waived the right to preliminary examination. The offer I've extended thus far to the defense is that we would reduce the count 1 possession with intent to deliver 50 to 400 to an under 50 grams, which lowers his guideline grid as I have 4th. And then I would reduce the felony firearm 2nd to a felony firearm 1st, and that negotiations would continue. And in fact, negotiations did just continue out in the hallway. But for purposes of waiver, that's the offer. Your Honor, I just wanted to note for the record that on the information filed in circuit court, I'm going to be striking as it pertains to the possession by prohibited person, firearm, and ammunition. Specified felonies listed as possession with intent to deliver. It's going to read in circuit court possession less than 25. I have spoken to Mr. Perone. He has no objection. Thank you.
You can approach. That's correct, Mr.
No
Perone?
objection.
Okay, and so, Mr. Giles, that's how you pronounce it, Giles?
Yes, ma'am.
Okay, you understand that you have the right to have a preliminary examination in this file?
Yes, ma'am.
You understand you have the right to require that the prosecution establish that they have sufficient probable cause that these felonies were committed, and then sufficient probable cause to charge you as the person who committed these felonies?
Yes, ma'am.
You want to unconditionally waive your examination?
Yes, ma'am.
No one's threatening you to do that, correct?
No.
No promises not stated on the record. that you will. Okay. Thank you. I find your waiver to be freely and voluntarily made. Your bind over date is July 1st. That is not a court date for you though, okay?
Yes.
That's the date the circuit court's gonna receive this file. They'll then set it for a pretrial. Your attorney will be made aware of that, okay?
Yes, ma'am.
The bond was set at 5,000 personal recognizance. That will continue. Any additional matters?
Not on behalf of people, Your Honor, thank you.
No, Your Honor, thank you.
Thank you. You're all set. Are we ready, Mr. Austin?
I believe so, Your Honor.
Okay, we're back on the record in that matter of the manual Porter. And Mr. Porter had just learned that the bind over would, or the people are requesting to bind over with 2 additional counts of felony firearm. Obviously, you don't have to consent to those 2 counts. You can run an exam, and then if they find or lay the foundation for additional counts, then they'll be added. But that's up to you. I'm sure you spoke with your attorney about what's at stake. So how do you want to proceed, or do you know how you want to proceed at this time? How do you want to proceed? You want to waive your examination? Okay, and so you understand the purpose of the examination, correct? I can't hear you? Okay, so you have the right to require the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the person who committed the felonies. You understand that? Can you say that so that the record hears you? Okay, and no one's threatening you to waive your exam? No promises to get you to waive your exam? Yes, thank you. Okay, your bind over date is July 1st. That's the date the circuit court's receiving this file, not a court date for you, okay, sir? The next court date will be set after they receive the file. There'll be a pretrial. Mr. Austin will be made aware of that. A bond is set at 75,000. That surety that will continue with GPS tether and a no contact order. Any additional matters for the record?
Not at this time, Your Honor, thank you.
You're all set. Okay, we're gonna bring up Demond Fortuner?
Yes.
Okay, very good. You're all set. Mr. Austin? Mr. Carter? What do you need?
I give you a statement, I don't receive my social security pension until August first.
Till August?
First.
We just need to file, right? Yeah, that's fine.
Okay. Yeah.
First. Write that on the sticky so you can remember whenever.
yeah.
This is the state of Michigan versus, is it Demond?
Yes, ma'am.
Okay, Porter, 26-01442.
Morning, Honor, Natalie Nakamura on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194. We have Mr. Porter. Mom, please state your name for the record.
Mine's Tyrell Porter.
Okay, Mr. Porter is one of the co-defendants for the armed robbery carjacking. He was scheduled for a preliminary examination today. And my understanding is that he does not wish to run his exam.
That's correct, Your Honor. We're going to make an unconditional waiver, and I'm working on circuit court resolution. I've discussed that with him and his sister.
And that waiver would include the added 2 counts of felony firearm.
That's correct, Judge. And I may briefly, when we're done, be heard on bond.
You were aware of the 2 added counts, correct?
Yes, ma'am.
Okay, so you understand, Mr. Porter, that you have the right to require at this stage that the prosecution first establish that they have sufficient probable cause that the felonies that you're being charged with were committed.
Yes, ma'am, I do.
Okay, and you have the right to require them to establish sufficient probable cause that you were the person who committed the felonies, correct?
Yes, ma'am, I do.
And you want to waive that unconditionally?
Yes, ma'am.
No one's threatening you to do that, correct?
No, ma'am.
The bind over date is July 1st. That's the date the circuit court's receiving the district court file. It's not a court appearance date for you, okay?
Yes, ma'am.
Your next court date will be a pretrial in the circuit court. Your attorney will be made aware of that, okay?
Yes, ma'am.
Okay, looks like the bond was denied under Michigan Court Rule 6.909A2B. You want to address bond
Thank
today?
you, Your Honor. My client has no prior felonies. He's been sitting inside for a couple of weeks. He's got family he can remain with. While I'm not formally a retained lawyer, I'm not going anywhere on this case. I intend to advocate for him. Today was one move towards strategy. I asked that his bond be at a reasonable cash bond. I think is fair here, Your Honor.
Did the prosecution want to address that?
Thank you, Your Honor. Your Honor, while the people stand by what was said at arraignment regarding bond, I also cannot stand here in good faith and ask the court to continue to deny bond, and the other two co-defendants have a $75,000 cash or surety bond. So I'd ask the court, if the court is going to reduce bond, to set it at the same as the co-defendant, $75,000 cash.
If I could briefly reply to that, Judge.
Okay.
Well, I still think 75,000. I think it's fair that all three co-defendants would have the same bond. So I'd ask you to at least consider that. Thank you.
Bond is set at 75,000 cash surety with GPS tether. And a curfew. Not to be outside between the hours of 7 PM and 7 AM unless you have verified employment during that time. Do you have any questions at this time about your bond condition?
Ma'am.
All previous bond conditions included a no contact order will continue. Any additional matters for the record?
Nothing to defend, Your Honor. Thank you.
You're all set. That's what you was waiting.
You guys want to vote that slide? How many times? Was it?
All we could do is, Lord Jesus. Okay, so we are running Simpson, we're running Ford, and we're running Jones.
Sounds correct to me.
Jones first. State of Michigan versus Clayshawn Jones. Okay, appearance for the record.
Ross Marchino for the people.
Luke Goodrich from the Public Defender's Office, here to represent Mr. Jones, who's standing to my right.
Should we preliminary matters before we call witnesses?
Nothing on behalf of the people.
Nothing on behalf of the defense, Your Honor.
You call a witness, you can have a seat.
The people called DeShayla Carter.
I have some in here.
Oh,
I just have a collection of things that probably need to go in the trash now. Old dockets. Probably because I was supposed to find notes that never got put in. And Austin can take that, okay? You want them notes in like that, Austin? Right. I'll put them in yourself.
we'll come right here and then turn to face the judge.
You can take your hood off. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can have a seat. Have you ever testified in court before? Okay, so there's a microphone that's in front of you. That microphone will not make your voice louder in the courtroom though. It's only for the system to record your responses. Everything stated in court must be recorded, okay? So we need you to keep your voice loud and clear as if you were speaking to someone in the back row there. Everyone needs to be able to hear, okay? If there's an objection to any of the questions, you have to stop speaking. You can't give us the answer if someone says objection. That requires me to make a ruling on the objection, and then I'll tell you if you're allowed to give us the answer to their question or not. You need to answer all yes or no questions with yes or no's, because we can't understand mm-hs, uh-hs, or head nods, head shakes on the record. If you forget, which is common, we will remind you, okay? Okay. If you could state your first and last name and then spell both. Shayla Carter, P-A-S-H-A-Y-L-A-C-A-R-T-E-R. You can proceed, counsel.
All right, thank you for being here, DeShayla. We're going to talk about April 27th of 2026. Do you remember that day?
Yes, I do.
And did you find yourself at 1411 North High Street that day?
Yes.
And that location, is it in the city of Lansing?
Yes.
Is it in Ingham County?
I believe so.
Now, what kind of location is that?
Um,
Is it like a house, an office building?
it's a house.
And how many people were at the house that day?
Six people.
Do you remember who all was at the house?
Yeah.
Could you tell me who was at the house with you that day?
Clay, Monte, Swan, his sister, I don't really know her name. And then I had a friend, her name is Gio. I have her, but she was.
Now, let's start with Twan. Is Twan the person who lives at that house?
I believe so, yeah.
And how do you know Twan?
Like from another friend.
So like
I really don't
a
know
friend of
him.
a friend?
Yeah,
And you mentioned Monte. Who is Monte?
supposed to be a friend.
Someone who you believed at the time to be a friend of yours?
Yeah,
And now let's talk about Clay. Do you see Clay in the courtroom right now?
yeah.
Could you please tell me where Clay is sitting and describe his clothes?
He's sitting to your right,
What's he wearing?
great.
Your Honor, could the record reflect the witness have identified the defendant?
Any objection?
No objection, Your Honor.
Identification is noted for the record.
And you also indicated that, did you say that Schwann's sister was present?
She wasn't, she was there, but she wasn't like present to us. She was upstairs.
And when you went to this house, did you have any particular purpose or were you just hanging out with the people there?
Just hanging out.
And when you were at the house, did you see any weapons?
Not at first, no.
Did there come a time when you saw any weapons just out?
Yeah, like later on.
Okay. And where were these weapons that you saw?
On person.
Now, you identified Clay. Let me take a step back. Did you have anything with you when you were at the house?
I had my tattoo equipment, my phone, money. That was it.
Now, your tattoo equipment, do you do tattoos like professionally?
Not professionally, but yeah, I do.
You do tattoos and you had your equipment for the tattoos with you.
Yes.
And was that inside of any sort of container?
No, it was just all in my backpack.
Okay, so it was in a backpack. Is that a yes?
Yes.
Now, you indicated you had money. How much money did you have?
I had a little over $500.
And was this in cash?
Yes.
Was this also in your backpack?
No, it was in my pocket.
Now, did there come a time when you saw Clay with a gun?
Yes.
And at the time that Clay had a gun, where were you in the house?
I was on the couch, downstairs on the couch.
And this couch is in like a living room?
The living room.
Was anybody else in the living room with you at this time?
Twan was in the living room and Monte was. Monte was on the couch, sleep, and Twan was on the couch, just on the phone.
And when you saw Clay with this gun, was he already in the room or had he left and come back?
He had left and then he came back.
And when he came back to the room, did you immediately see the gun?
Not immediately. He left, came back, and then picked it up again.
Okay, so where was the gun when he picked it up?
I believe it was on the couch.
And can you describe the gun for me?
It was like, it looked like a Glock, but it wasn't, and it had a long clip, extended clip.
So when you say it looked like a Glock, it was like a handgun?
Yeah,
And when you say extended clip, as in the magazine with the bullets was going past the bottom of the gun?
yes.
Do you remember what color the gun was?
It was like black, grayish.
Black and grayish. And was the extended magazine the same color as the gun?
I don't know, I wasn't paying attention to the gun that hard.
Okay. Now, when he picked up the gun, did he say anything to you?
Nah, he just picked up the gun and said, I'm gonna shake this bitch, turn this bitch up or something. Then he went upstairs.
So he made those comments and went upstairs with the gun?
Yeah, he went upstairs, Twan went upstairs, he went upstairs, and Monte went in the kitchen. And that's when I knew, like, they was trying to set me up.
So all three of them left after he picked up the gun and said that?
No. Monte went in the kitchen. Twan went upstairs. He went in the kitchen with Monte for like 5 seconds, walked past me with the gun, made a comment, went upstairs to Twan. That's when he came downstairs, and then that's when he had the guns in my face.
Okay, so that was a great recollection of the timeline. After all of that, you said he had the gun in your face. Does that mean he was pointing the gun at you?
Yes.
And how close was he to you when he was pointing the gun at you?
Like 2-3 feet,
And how close to your face was the gun?
like 5 feet.
And did he say anything to you when he pointed the gun at you?
He said, he was like, I need all your shit, something like it was along the lines was, I need everything you got, or I need all the shit you got, or something like
And when he first said this, did you think you were being serious, or did you think he was being serious, or did you think he was making some kind of joke?
that. No, I thought he was playing at first.
And at what point did you come to realize that he might have been serious?
When he started shaking,
When you say he started shaking, can you sort of describe the shaking for me?
like he had the gun up to me, and then he said, I need all your shit. Then he was like, I'm not playing, I'm not playing. Then he started shaking behind the gun. Then he started backing back. Then that's when I got it. I didn't even get up there. He started backing back, and I looked at my 2 other supposed to be friends, and I was like, for real, for real. I'm like, y'all, for real. They was basically saying that they didn't know none of
Okay,
this.
we'll
was
we'll
gonna
stop
happen.
there for now. Again, a great recollection of what happened. Just for the transcript, when the witness was describing the shaking, she held up her right hand as if she was holding a gun, and then she demonstrated her hand sort of shaking back and forth. And then, so at this point, did you come to realize that he was serious about wanting your belongings?
Yes,
And did you then give him your belongings?
not at first, no.
Did you eventually give him your belongings?
Eventually, yes.
And what caused you to change your mind and give him your property?
When I see that, I knew that I don't see him being that type of person, but when I seen it in his eyes, like he'll prove a point if he have to. So I just went along with it. I didn't give him everything out of my pocket, but I try to like give him something to get him off him.
Okay. And what all did you give him?
I gave him a few $100s.
And did you give him your backpack with the tattoo equipment?
No, he was trying to take it, but I didn't let him.
Did he eventually agreed, I guess, to let you keep the backpack with the tattoo equipment?
Yeah, he was like, you could keep this. He's trying to take my phone. Was trying to let him take my phone. He made me power off my phone before I let the porch.
Okay. So he, to just make sure I'm understanding, he tried to take money, phone, and backpack, but ultimately only took money.
Yes,
And you indicated he took a few $100s.
yes.
Now, what is this about him having you power off your phone?
I guess he didn't want me to call the cops or something.
But he did let you leave.
Yeah,
And then when you left the house, where did you go?
at first I went like 2-3 houses down. I powered my phone on, then my phone powered on, then I walked to the store.
And when you went to the store, did you at this point call the police?
Not at first, no.
Did you eventually call the police?
Yes.
How much time would you guess went by between leaving the house and calling the police?
I'll say 30 to 40 minutes maybe.
And why did you wait 30 to 40 minutes?
At first I was on the phone with my ride. I was worried about leaving the area more so than, no,
So your first priority was getting away from Clay rather than calling the police?
yeah.
And going back to when he was pointing the gun at you, were you afraid that he was going to use the gun if you didn't turn over your belongings?
I wouldn't say afraid, but I had like some suspicion that he would use it.
And the possibility of him using the gun, is that why you gave him your money?
Yeah.
Give me 1 second, just make sure I got everything. Okay, the people have no further questions.
morning, Ms. Carter.
Mm,
Ms. Carter, who was it that initially invited you over to this house on Hunt Street?
I wasn't invited. I texted Monte to
Okay.
see if I could go over to his house for a few hours. But he said, instead of just my house, we could go to Twan's house.
Okay, so it was Monte who invited you over to Twan's house, since that's where he was at?
I guess you could say he invited me, but I met Monte at his house. And we
Okay.
went to Twan's house for
I
Monte.
got you. And Monte, somebody that you'd known for a while?
Yeah.
And was Twan somebody you'd known for a little while too? Roughly how long had you known each of those individuals?
3-4 years.
Okay. And how long had you known Clay prior to that date?
I just met him that day.
That was the first time you'd ever met him?
Yeah.
And do you know about what time of day it was when you first get to the house there?
No,
Were you there several hours prior to any incidents occurring?
I was there for about 5-6 hours.
When you first got there, were there guns out in the living room area to be seen?
No, not when I first got there.
And you said after a couple hours that Mr. Jones eventually left the place?
Yeah.
And had you spoken to Mr. Jones prior to him leaving?
Yeah, he was supposed to get a tattoo.
Okay. Did you go there? Did you give a tattoo to Twan's sister at all that day?
I gave her an initial on her finger.
Okay, so just kind of a little small one.
Yeah.
That was essentially kind of a business that you did on the side.
Yeah.
And all right. And then you stated, like I said, that Mr. Jones got up and left at some point.
Yeah.
Who was at the residence during the time he was away?
Swan, Monte, Swan's sister, and my friend Gio, but she ended up leaving.
When did she leave prior to Mr. Jones coming back to the residence?
I can't remember if she left before or after him coming back.
Okay. When did you first start seeing the guns in kind of the common area? Did Twan or Monte bring those down while he was gone, or what are we talking about?
When I first seen the guns, they was on the people who owned, quote unquote, owned the guns. So like, I really don't know
Well,
when. It was just like an out the blue thing.
Who are the people who own the quote unquote own the guns?
Monte and Twan.
Okay, so each one of those individuals had a gun on them,
Yes.
and then the guns were set down in the living room area at some point?
One of them was, yes.
One of them was. Did you inform either Twan or Monte that you had some cash on you from doing this tattoo work?
I didn't even make money from that tattoo.
Okay, so Twan's sister didn't pay you, you did it for
No,
free?
she only gave me $8 for it.
$8,
Yeah.
okay. So all that the people there would have seen was the $8, is that fair to say? And then they said you testified that Monte and Twan kind of left the living room area. And that it was, you said Mr. Jones was the only person in the living room with you at that time?
No.
Who else was in the living room?
Monte went to the kitchen. Clay followed after him. And Twan went upstairs. Clay came right out the kitchen and went straight upstairs.
Okay, so based on what you saw, Clay kind of followed Monte to the kitchen and then he followed Twan upstairs?
Yes.
And that it was after that you claim he came downstairs and grabbed the gun?
He did. He already had the gun.
So did one of those other two individuals give him the gun? Where did
I
that come?
believe so, yes.
And you stated his hands were shaking as he was holding the firearm.
Yeah,
And then you were basically able to negotiate, giving him a couple $100 instead of all of your money.
we didn't negotiate nothing.
Well, you claim, you testified that he said to give you all of your belongings, correct?
He had the gun to my face, telling me to give him stuff.
Okay, and you gave him some of the items, but not all of the items.
Yes,
And when it came to your backpack, he let you keep the backpack?
yes.
Okay, and then were you ever struck or assaulted at any time? Yeah, physically assaulted at any point?
No,
Thank you. I have no further questions at this time.
Committee reserve.
No, Your Honor.
Make excuse.
You're good to go.
Any additional witnesses?
Your Honor, people rest.
The defense calling witnesses today.
No, we're not calling any witnesses today, Your Honor.
Argument.
Okay, Your Honor, the people are going to request bind over on the 2 felony charges, the first of which being armed robbery. I direct the court to jury instruction, model instruction 18.1 for the elements of this offense. First, the defendant, and there are 3 options here: use force or violence, assaulted, put in fear. I believe the second and third are applicable here. As far as put in fear, I understand the witness testified, well, I wasn't afraid. I got the sense that she was kind of unwilling to admit to being fearful, but I think we can infer that someone putting a gun in your face and you believing they intended to use the gun would put a person in fear. But regardless, we also clearly have an assault with a gun being put in her face, and she reasonably believed that he intended to use the gun absent her compliance with his demands to turn over money. Second, the defendant did so while in the course of committing a larceny. Clearly, I won't go through the definition of larceny. Clearly, he took money away from her and had the intent to permanently deprive. We can infer this intent to permanently deprive by, I'm not going to put a gun to your face and say, give me the money, and then, okay, I see you have your money, thank you, you may have it back now. I think we can infer the intent to permanently deprive. Third, DeShayla Carter was present while the defendant was in the course of committing the larceny. That pretty much speaks for itself. And fourth, while in the course of committing the larceny, the defendant will go with possessed weapon designed to be dangerous and capable of causing death or serious injury. That's clearly what a gun is for, to cause death and serious injury. And then obviously in the alternative, an object used or fashioned in a manner that led the person present to reasonably believe it's a dangerous weapon, even if we try to argue, oh, this could have been a BB gun with tape on the orange thing. Well, then we have option C. It was clearly designed to make her believe he had a gun. And then the fifth element is not appropriate in this instance. And then count 2 is the felony firearm. We of course have testimony unequivocally that he had a gun in the course of committing this armed robbery, and that is sufficient to bind over on count 2. And we did also establish both identity and thank you.
Your Honor, at this time, we would leave the prosecutor to their proofs in this matter.
Thank you. Today's a date scheduled for preliminary examination. The burden is on the prosecution to establish sufficient probable cause that the felony you've been charged with or felonies you've been charged with were committed, and sufficient probable cause to charge you as the individual who committed those felonies. This is not trial. They don't have to prove each element beyond a reasonable doubt. They just need to provide the court with more than mere suspicion that these crimes occurred. So I'm the only determiner here at this stage of credibility issues. And then I'll also weigh the likelihood of the people's success if this were to go to trial. We had testimony from one witness today, that being a DeShayla Carter. She testified that on or about April 26, 2026, that she was present at the address of 1411 North High Street, Lansing, Ingham County. That makes venue in this court appropriate. That she was there. There was approximately 6 people present at the home. At some point, she said she identified the person seated to the side of you, Mr. Goodrich, as Mr. Clayshawn Jones, the defendant in this particular case. And she said that she was at the location hanging out. And she had her tattoo equipment for about $500 or a little bit more than that. And her telephone, that she said she heard an individual by the name of Twan and Monte, that they were with her, or her alleged friends were with her. She said Mr. Clay left the room. She did not see him present with a firearm prior to, but that when he returned, that he did have a firearm, that he made some statements along the lines of, I'm finna shake this bitch, or I'm gonna turn this bitch up, or something to that effect, is an exact quote. That he then approached her, put the gun to her face, that I need all you, or all your stuff or belongings, that the gun, she said that he had the gun to her face, that she didn't believe he was serious at first, but that shifted when she noticed that his hands started shaking and then he started backing towards her. And that she did give or turn over portions of her belongings, that being currency. She said she didn't give him all of her money, but a couple of $100, and then she gave him, or she did not give him her cell phone, that she was leaving, and he required her to power down her phone. Her belief was that so that she could not call the police. The prosecution has gone over the elements in the element, or I guess the most questionable statement made by the witness, which I find her to be credible, was the statement as to whether or not she was placed in fear. I believe if she wasn't in fear, she wouldn't have turned over the money. But even if that's the case, I do believe that there is sufficient probable cause as to count, or element one, that is, that the defendant used force or violence against her. And I believe that the force or violence caused fear, and that it was an assault, that being with a firearm. And so I do find sufficient basis that to meet all the additional elements, particularly as it occurs to the fourth element, is that while in the course of committing the larceny, the defendant possessed a weapon designed to be a dangerous weapon or capable of causing death or injury, or in the alternative C, that he possessed any other object that's used or fashioned in a manner to lead the person who was present to really believe that it was a dangerous weapon. She testified it was a firearm, but she believed it was a firearm. To the extent that there's an argument that it was something other than a firearm, it was used, or it was an object used or fashioned in a manner that would cause at least Ms. Carter to believe it was a firearm. The court is satisfied that the foundation has been met for probable cause, and this will be bound over to the circuit court. Find over date is July 1st. That's the date the circuit court's going to receive this file, not a court date for you, Mr. Jones. You understand that?
Yes.
Your next court date will be a pre-trial, and that will be held, or actually that would be scheduled after the circuit court receives this file. You're going to stay in contact with Mr. Goodrich during that time, okay? So he can give you any necessary updates. Do you have any questions today?
No.
Bond is set at 50,000, 10% with GPS tether. Do you have a tether on, correct? With victim notification if possible, and exclusion zones. What's your home address?
1526 Bella Street,
And your phone number.
517-377-5958.
That bond will continue. Any additional matters for the record?
This is probably a stupid question, but the court is finding over on both counts.
That's correct. I'm sorry. I didn't address the felony firearm. Felony firearm, the court is satisfied that there's probable cause that a firearm was used to commit or in the commission of a felony. That will be bound over as well.
Nothing further from the defense, Your Honor.
Thank you.
Is the court planning to do Simpson next?
My understanding is that they're requesting an adjournment now. The man that just left? No. Oh, okay. I heard her say something about that. Okay. People perish for lack of knowledge.
I think there's somebody at the back staircase.
Or are they doing work on the?
I don't know if that's happening. I was told I wasn't allowed to go check.
In the back, what's the back there?
Oh.
The ones doing construction? What's that banging?
I think it's down that hallway where the, 'cause it's coming
Back
that
there.
way. The staircase, I would assume.
They say you couldn't go check.
Well, Barry's will have to go down there.
He's looking out for you. We don't know what's in the hallway.
He died in scary movies, and I said, well,
Oh my gosh. Somebody, it sounds like someone's kicking the door.
I know. That's why I really wanted to go look, because I'm like, okay.
Security is here for that purpose and armed.
I know, I'm just nosy.
Definitely a scary movie situation.
I am that person.
I think they're doing maintenance upstairs.
There we go. Something's banging.
I know it's not back there, it's not on the floor.
Oh, see, I would.
You ready? Are you all ready?
Yeah.
Oh, okay, state of Michigan. This is Davion Simpson, is that correct?
Diavion, Your Honor.
Oh, Diavion Simpson, 26-01441.
Good morning, Your Honor. Natalie Nickenber on behalf of the people.
Or Your Honor, Ronald Berry, appearing on behalf of Mr. Simpson, who is standing to my right at the council table.
Okay, Mr. Simpson was scheduled today for a preliminary examination on armed robbery and carjacking. And my understanding is that there may be a need for an adjournment.
That's correct, Your Honor. There are some legal matters that both parties would like to pursue prior to running a preliminary examination. So we asked the court to entertain a one-time adjournment in order to accomplish that.
That's correct, Your Honor. It's not something we feel comfortable stating on the record, just because there's people I know in the courtroom as well as YouTube watching.
If you want me to grant it, you're gonna want to approach and tell me.
Yes, Your Honor, thank you.
Okay, Mr. Simpson, you have the right to have a preliminary examination within 21 days of the date that you're arraigned. Are you willing to waive the timeline so this can be reset so that you and your attorney can work further on your defense?
Just the adjournment past the 21 days. We should not be hearing music.
You're willing to do that? Okay. July 16th at 8:30. That works for you, Mr. Berry?
I heard it.
July 16th?
16th.
16th, 1/6.
At 1:30.
Yes.
Works for me, thank you.
8:30? 8:30.
Oh, 8:30. Both work for me. I don't have anything on schedule today.
Okay, sounds good. So we'll set it for that date and time. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor, thank you.
You're all set for today.
boy.
You all can just sit, excuse me, if you all can sit tight while we escort him out.
Yeah, but
Mr. Ford. State of Michigan versus Christopher Ford. 0153, appearance, please.
Ross Marks, Phoenix, for the people.
And thank you, Your Honor. Good afternoon. Jared Austin appearing on behalf of Mr. Ford. He's present to my right at council table.
This matter is ready to go to exam. Any preliminary matters?
Yes, Your Honor. First, the people have what's been marked as proposed exhibit 1, showing that the offense table is a certified judgment of sentence for I believe, 2016 conviction of delivery manufacture of controlled substance less than 50 grams, which is a specified felony. People have moved to admit proposed exhibit 1.
Admitted.
May I publish the report?
Yes. Careful.
I'll fall down on the way.
Any additional matters?
Yes, the people would also know we have 2 witnesses in this matter, one of whom is Zachariah Vanderwerf, and he might currently be testifying in front of Judge Ward. So if we do have to call the other witness first, it'll just be a little out of order in terms of how the case is being presented.
Sounds good. Any other preliminary matters?
Nothing from the people.
Just- And I would just ask for an order of sequestration, given there's multiple witnesses.
Sequestration is granted. You call your witnesses.
Okay, the people will be calling either Patrick Muller or Zachariah Vanderwerf, depending on whether Mr. Vanderwerf is currently available.
Or who you have. Oh, is that still in your desk? I think we might have a letter for you, Mr. Martinez. Okay, we'll just take a break on this one. I have a sentencing being brought up now, and then we'll get back on the record. Did
Yeah.
they come take care of Buchanan's pieces? No, they still have some, and then somebody needs to be arraigned on a PA 53 violation. They just received yesterday, so. Good, who's this one? What's up, Prince? Buchanan's prosecutor.
Buchanan's prosecutor.
Pick a name out of a hat, that's who we're prosecuting.
I thought it was Mr. Bird.
Yeah.
Okay,
that's
so
it.
in
Bird.
theory, misdemeanor days, it's Miss Buckingham, who of course is not a licensed attorney and will be taking some time away soon for the bar exam.
She'll be fine.
And then in felony days, it's Andrew Burge, who's currently in Italy. So.
Oh. So who's handling her PCC? That's who she put in this email with him, Burge.
Judge, you want to run? Mr. Dodge.
Yeah, we can just do a sentence. State of Michigan versus Jaden Dodge and 26-00024. Parents, please.
Ross Martina for the people.
Assistant Public Defender Joseph Purdy on behalf of Mr. Dodge.
Today was a date scheduled for sentencing. And there was no pre-sentence report prepared, and that was at my direction. Because I was advised that he is not eligible for sentencing under 769.4A. And he's already served 88 days.
Yeah, our request was just going to be for the time served. Your Honor.
By the time, sir. You're all set. Does he have a PA 53?
So as part of the plea deal, there was prosecution did recommend dismissal of the K-53. It's my understanding that the court was going to hold it until.
That was he picked up a felony RNO with the victim. And he was with the victim. Is that what does he have something? Does he have something pursuing? He has an RNO. The felony. Yeah, that was that and the. I'm gonna cover it up. I was trying. He's also. Yeah, I said I would hold the violation in advance. Okay, are we ready to proceed? Okay, back on the record, you can call your next witness for this matter.
Thank you, Your Honor. The people now call Zachariah Van.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can have a seat. State your first and last name and spell both.
Yeah, Officer Zachariah Vanderwerf. First name is spelled as Zachariah. Last name is Vander, capital WERF. Officer Vanderwerf, how are you employed? With the City of Lansing Police Department. And how long have you been so employed? 9 years. What's your role with the City of Lansing Police Department? Currently, I work with our VCI team, but at the time of this incident, I was working shift road patrol. And are you referring to an incident that took place in February of 2023? Yes. And road patrol, what does that entail? Responding to 911 calls for service typically. And were you working on it as a road patrol officer on February 26, 2023? Yes. And did you find yourself in a marked squad car with another officer? Yes. And were you the driver or the passenger in the squad car? I was the driver. And did you observe any vehicles doing anything unusual? Yes. So I was at the intersection of North Washington and Cesar Chavez when I observed a silver Chevy Impala pass me. I attempted to turn around on the vehicle, and then at that time it made a turn down Kilbourne Street, which is a dead end. So at that time I kind of just sat and waited and see if the vehicle was going to come back out. It did. Which led me to believe that it was trying to avoid me. So I tried to get behind it a second time near like Walnut and Maple Street. And at that time it had pulled into a driveway. And when it pulled into the driveway, I observed it had expired tags. So I was trying to turn around to be able to initial traffic stop on it for the expired tags. So when you say expired tabs, like tabs on the license plate? Yes. And what, if you recall, was the point in time that tag expired? Well, I don't recall that. If you were to take a look at the police report, would that refresh your memory? As to when it expired? Yes. Right. Showing defense table, the witness's police report. Your Honor, may I approach the witness?
Okay.
Approach the witness with the police report. Did that refresh your memory? Yes. When did this tag expire? May of 2022. And you indicated that this was February of 2023? Yes. And is it legal to operate a motor vehicle on a public roadway with an expired tag? No. So at that point, did you believe you were justified in stopping the vehicle? Yes. Even though it had already stopped. Did you observe the driver of the vehicle at this point? Yes, I did. So initially when it passed me at North Washington, Cesar Chavez, I observed who the driver of the vehicle was. And this North Washington Cesar Chavez location is in the city of Lansing? Yes. Is in Ingham County? Yes. And after the vehicle stopped, you said it stopped in a driveway? So it pulled into a driveway, and then when I went to turn around to initiate the stop, it had actually stopped. It had taken a turn onto Walnut Street from Maple. And then when I came around the corner, that's when I saw the vehicle parked there. Okay. And then at this point, did you activate your overhead lights? Yes. So I observed the driver, which was Mr. Ford, walking across the street, which I activated my overhead lights on my patrol vehicle. And did you see him exit the car? I don't believe I saw him exit the car, no. How did you know that he was the driver? So I had asked him if he had just got out of that car, and he said yes. And then he told me he had expired tags. So he volunteered the information to you that the tags were expired? Yes. And at this point, did you make any requests of him? Yeah, I asked, he gave me consent to pat him down, which he did. He allowed me to do so. And then at that time, I had him step back over by the vehicle. And even just prior to that, when I was patting him down, I asked if he was trying to avoid me due to the expired tags on the car. And he said yes, that he was. And did he give any indication of any other reasons why he shouldn't have been driving that car? Yeah, because when I asked for his driver's license, he also said that was another reason, because he didn't have a license. And is it common police practice to allow someone to drive away in a vehicle with expired tags and without a license? No. At this point, is it common practice to have a vehicle towed? Yes. And when a vehicle is towed, is it common police practice to search the vehicle to take inventory of what's in it? Yes. Okay. So now going back, at this point, he's been pulled over for the tag. He's admitted to not having a license. Did you ask for permission to search the car? He actually volunteered that information initially, and he said that I could search the car, giving me consent. And then later I had asked him again, I said, so you're okay with us searching the vehicle? And he said he was okay with that. Okay, so he, on his own, offered to let you search the car, and then later you confirmed we can search the car, and he said yes again? Yeah. And at this point, did you begin to search the car, or did Officer Brown begin to search the car? Officer Ella Brown did. Okay. And can you sort of describe what the person identified as Mr. Ford, can you describe what he was doing? Yeah, so I had him, while she was conducting her search, I had him sit on the front hood of his vehicle facing me. This was an effort to just be able to watch him and keep my partner safe as she was doing the search of the vehicle. I made some observations while she was conducting that search. Some of those observations were that when she was searching the driver's side of the vehicle, I watched him turn around approximately 3 times to look to see what she was doing. And it's pretty easy to notice at that point, because due to how he's sitting on a vehicle, you have to turn around to look to see what she's doing. Well, as she moved around the vehicle, I noticed that when she was on the passenger side searching, she never was looking at her. So this had me concerned that there might be something inside of the vehicle based on my training experience. So just to, I'm sorry to cut in. Yeah, go ahead. Did that make the fact that he was intently watching her search the driver's side, not the passenger side, did that cause you to become suspicious specifically of a certain part of the vehicle? Yeah, so it made me suspicious of the driver's side of the vehicle. Now, at this point in time, was it still just you and Officer Brown on scene, or had anyone else come? At some point, Officer Moeller did arrive, but I don't think he had arrived at that point. And just to backtrack a little, the driver of that car, Mr. Ford, do you see him in the room right now? Yes, I do. Could you please tell me where he's sitting and describe his clothing? Yes, he's sitting right there wearing the black jacket. The witness did point towards defense table, and Your Honor, for the record, reflect the witness identified the defendant.
Any objection?
Without objection.
So noted.
So upon making those observations of Mr. Ford that raised your suspicions, did you then go and assist in searching the car? Yes, so then I went to specifically the driver's seat of the vehicle, and then I began to search that area, and I observed that he looked at me approximately 5 times. So we're probably up to like about 8 times that he's looking in this particular location. And was he only doing the turning around and looking when it was the driver's area being searched? Yeah, that seemed to be the area of interest. Now, was he the only person who had been in the car? Yes, he was the sole occupant of the vehicle. And then did there come a time when another officer arrived? Yeah, so Officer Mueller arrived, and then I just kind of made him aware of some of the observations that I had, and then he searched the vehicle and located the fire. And how much time elapsed between you searching the vehicle and him searching the vehicle? I don't recall that off. Okay. But at any point, did Mr. Ford say, you know what, actually, I changed my mind, I don't want you to search the car? No, he never said that. And when Officer Mueller went and searched the car, did he say, actually, I changed my mind, I don't want there to be any more searching? No, he didn't say that. Okay. Did he give you any indication that he would be revoking his consent to the search at any point? No. And you indicated that Officer Mueller found the firearm. Did you personally see the firearm? Yes, I did. All the questions I have, thank you.
Oh, I didn't hear it. Okay. Good afternoon, officer.
Good afternoon.
So I understand that you're doing patrol and you at some point see the vehicle at some point that you said that Mr. Ford was driving. Is that correct? Yes. And did I understand your testimony correctly that you said you attempted to do a turnaround on that?
Yeah, so like a U-turn.
Okay. And what was it that caused you or prompted you to do that?
So when he actually passed by, it was like he was trying to conceal his face. When I was driving by, like he was trying to conceal his identity when he passed me.
What was he doing that led you to believe that?
because he had put his arm up like this and kind of put his head down like this as he was passing, turning in front of me, because he's taking a left off of Cedar Chavez in front of me, and I'm like in the left lane right here, so he's coming past me.
And so you were gesturing that he was driving and you held up your left arm. Is that correct?
Yeah, I believe it's left arm, yeah.
Okay. And that would have been towards the left side then of his face then, is that correct? Okay. Is that a yes?
Yes, yes.
He was not doing anything to cover the front part of his face, is that right?
No.
He didn't put any type of drapings or anything like that, either on the side of his face or in the front of his face,
No.
is that correct?
Nope.
You were still able to see his face though?
Yes.
And what time of the day or night is this that we're talking about?
It's nighttime.
Oh, it was dark out?
Yes.
And you stated at some point after the U-turn, you tried to get behind the vehicle a second time, is that right?
We're talking about the first initial time or the
Yes.
second time?
I believe I wrote down in your direct testimony, I think we're talking at some point after the U-turn now. I wrote down that you had stated that you tried to get behind the vehicle a second time.
Yes, I did.
Okay. And why was that?
Because at that point, because after he turns down Kilbourne Street, I was curious because that could potentially be where his residence is, and then he would not need to come back out onto the street because it's a dead end. But I waited there to see if he'd come back out, which would lead me to believe that he was trying to avoid me.
And you didn't initiate any type of a stop of the vehicle at those points, is that correct?
No.
And that's because the things that you were observing, the things that you were describing were not traffic infractions or civil infractions, is that correct?
At that point, no.
And at some point, if I understand your testimony correctly, you said you ended up running the tags on the vehicle, is that right?
At that point, I had not run the tags on it because I was trying to get behind it. But as I passed him, when he pulled into that driveway, I observed that the tags are expired.
Are you saying you made that observation just from looking at the tags, or you actually input the tag information into the lien system and found that out?
Yeah, so initially see the color because they're color coded, so I could tell it was expired by that. But yes, at some point I was able to run it through lien, which told me it was expired.
And was this simultaneous to your observation of the tags or sometime after that?
I can't recall if they were.
Was that you that did that or the other officer that was with you?
I can't recall that either.
And is that when you had initiated the contact?
Yes, after that, yes.
How soon after?
Well, I'll just describe it how I saw it. So as I passed him in the driveway and I was turning around, he had been backing out of that driveway, which was on Maple Street. And then as soon as he pulled out into the street, he then took a quick left to go northbound Walnut. And then by the time that I was turned around to get up there, the vehicle was parked on the side of Walnut and he was walking away from the car. So however long that took.
And that's when you initiated the contact.
Yes.
Okay. And did you activate the lights on the vehicle or anything at that?
Yes, I did.
Mr. Ford was out of the vehicle at that point, is that right?
Yes, he was.
Okay. And you'd stated that you did not see him exit the vehicle, was that correct?
No, I did not.
And but did you had contact with Mr. Ford and you told him to stop or what?
Yeah, I asked him if he could come talk to me.
Okay. And how far away was he from the vehicle when you did that, if you could estimate?
I think he was up on the sidewalk across the street from where it was parked. And then, because I was pulled up on the opposite side of the street where I opened my door to get out to talk to him.
Anybody else in the view?
No, there was not.
And where was the other officer that you were with at when you made contact with Mr. Brown?
Well,
Or Mr. Ford, I'm sorry.
She was seated in the front passenger seat and I believe she got out of the car with me and made contact with me.
And what was the purpose of you having contact with Mr. Ford at that point? Were you seeking to detain him, to arrest him? Was this an investigatory stop, something else?
It was for the expired tags.
You seeking to detain and question him about that, or was it in your mind at that point that you were there to place him under arrest for that?
It was not to place him under arrest.
What was your intention?
My intention was basically to conduct a traffic stop, but so yes, it was to detain and investigate further.
And did you tell or give Mr. Ford a reason as to why you were stopping him or having contact with him?
He actually offered that information up right away. He said, yeah, my tags are expired.
And it's your testimony that he offered that up without prompting?
Yes, without prompting.
And were you equipped with a body worn camera at this time?
Yes.
Okay, was that activated during this entire time?
I believe it was, yeah.
And was the vehicle that you were in, did it have any such recording device going as well?
I believe it does, yeah.
Does it capture audio as well, or just visual, your car?
I think it just depends on where you're located. I don't know if the car would have caught the audio or not, depending on where he's standing.
And so you're there with Mr. Ford and the vehicle, and you said that he gave you consent to search the vehicle. That's your testimony, as I understand. Okay. And did you perform or conduct some search of that vehicle?
Yes.
Okay. And what did you do in performing this search? What did you do? Where did you look?
Basically, all my attention was just focused on the driver's seat where I observed those observations from him. And so that's where I was at.
Did you open any compartments, any glove compartments, consoles, anything of that nature?
So I don't recall. That happened so long ago.
Okay. Well, let me ask this. It's safe to say you searched the vehicle and then at some point you were done looking in the vehicle or searching the vehicle. Is that fair to say?
Yeah, yes, that's fair to say.
Okay. And once you had stopped looking in the vehicle or once you had stopped searching through the vehicle, at that point, you had not detected or come across any type of contraband. Is that correct?
No, I did not.
Didn't come across a firearm. Is that correct? Okay. And so you're finished with that initial search. Is Officer Mueller on scene at this point?
I have to go back and watch my body cam when he arrives on scene.
So at your testimony today, you can't recall whether he would have arrived on scene while you were still conducting that first search or whether it was concluded at that point?
Yeah, I would have to rewatch it to be able to tell you.
Okay. And once you were done conducting the search of the vehicle, what were your next course of actions?
Well, my intent, because when I had originally called on the radio for another unit, my intent when he was the responding officer was for him to search it just because he has additional experience outside of my experience.
When you say that, what is that?
So he worked for our undercover drug team, our SOS team. So he has more experience with searching vehicles, things of that nature.
Are you saying he's somehow specially trained to
Yes.
search a vehicle in a way that you're not?
I don't know if he's specially trained, but I can say that he has special experience in that regard, more experience than I would have.
Do you have any reason to believe that you would find narcotics in the vehicle?
Not necessarily narcotics, but when Mr. Ford and I were talking, he said that he had been in trouble back in 2018. And at that time, he had told me that he had been in trouble for delivery and manufacturing. And then when I asked him what he had been in trouble, like what specifically was it? And he said it was crack.
And that was years earlier, is that correct?
Yeah.
Or that was
Yeah,
your understanding at
2018.
least? You didn't come across any drugs or detect any odor of drugs or alcohol in the vehicle, though, is that correct?
No.
And we know from your testimony, you're saying that the tags were expired. And do you recall coming across information as to who the vehicle was registered to?
Yes,
And safe to say that vehicle was not registered to Mr. Ford, is that right?
right. Yeah, Mr. Ford even told me that he was not the owner of the car.
Told you it wasn't his vehicle.
Yes.
You were asked some questions on direct as related to towing away of vehicles and when that might occur. Do you recall that line of questioning, sir?
Yes.
Okay, and that's a particular policy of the Lansing Police Department that you were talking about?
So as far as like policy is concerned with like no insurance we're talking about, or?
Yeah, or just when you may or may not tow a vehicle.
Yeah, we have policies for that.
Okay, is that a verbal policy or a written policy?
Written policy.
And this particular vehicle that we're talking about here, it was not towed or inventoried, is that correct?
It was not, no, because I got consent to search the vehicle.
At any point, was the vehicle ever towed away while you were there that you can recall?
Not that I can recall.
Anybody come and retrieve the vehicle?
I don't remember that.
Thank you, Your Honor. Solve the question by that.
Just to clarify, when you refer to lead, is that the law enforcement information network? Yes. No further redirect, thank you.
Okay, maybe excuse.
Thank you, Judge.
No. Yeah, witnesses.
No, the people were asked.
Any defense witnesses today?
No, Your Honor. Thank you.
Argument.
Thank you. Okay, we obviously have 3 felony counts here, and the people are going to request find over on all 3 of them. That's carrying concealed weapon, possession of a firearm by a prohibited person, although it looks like it still charges possession by a felon at that point in time, which is not a non-issue given the crime used as the basis for it. And then we have a count 3 felony firearm. Now, the court has been presented with People's Exhibit 1, which establishes a conviction of a specified felony, which further establishes that possession of a firearm by Mr. Ford would have him guilty of possession of a firearm by a felon. And I'm not going to go through the jury instructions on this one because I don't anticipate there will be a dispute that the testimony here establishes at a minimum probable cause to believe that Mr. Ford did commit these 3 felonies. Obviously, the felony firearm, whether or not we agree with the status of the law that a felony firearm can be attached to a prohibited person in possession of a firearm, that is the status of the law. So count 2 gives us count 3. I anticipate that any arguments from Mr. Austin are going to be with respect to the search. And I would submit that this is valid consent search. This wasn't even a traffic stop. I don't even have to defend a traffic stop. It's obviously Officer Vanderwerf activated his overhead lights on the basis of the observation that these tags were expired. But at this point in time, the defendant had left the vehicle and Officer Vanderwerf approached him. It sounds like the defendant kind of volunteered, yeah, my tags are expired. and then got consent for a pat down, asked for a driver's license, and he volunteered, yeah, I don't have a driver's license. So at this point in time, there's actually probable cause to make an arrest for driving without a license. That was not done at this point, but to the extent there is any arguments being made, oh, he was detained, there were police to detain him. Now, at this point, he volunteers consent to search the car. He says, you guys can search my car, and then they confirm, and I see him shaking his head right now, but that is the undisputed testimony that we have on this record, is that he consented to a search not once but twice. And I do want to focus on, there was testimony that he was watching pretty intently when the driver compartment of the vehicle was being searched. And I think that does demonstrate consciousness of guilt and sort of lends toward the possession element of both of these crimes. Obviously, the way the CCW is charged requires it simply be in the car. And to the extent the defense would want to argue, well, it was really tucked away in there, he didn't know it was there. I would make two comments on that. First, I would say, I think that the evidence suggests the reason he consented to the search is because he was so confident that it was hidden well enough that the police would not find him. To his credit, the first two officers who looked didn't find the gun. It wasn't until someone with more specialized experience in searching vehicles knew sort of the more clever places to look that they found the gun. And then as far as the consent goes, I think the argument we're going to have is that, well, this is actually two separate searches and they didn't get consent for this second search. And I guess to that, I would say, I don't think that this record supports any suggestion that these are separate searches. Obviously, we have multiple officers who are looking at this car. This is one continuous transaction, one continuous event of officers searching this car, investigating this expired tag, lack of license. I mean, it's obvious that they thought there was something in the car, right? This was one continuous event and consent was never revoked, even though I have a suspicion he probably regrets giving consent. And so we do have probable cause on all three felony counts. I would note that both witnesses identified the defendant and established this occurred in the city of Lansing County. Thank you.
Thank you, Your Honor. I'll start with some of the easy ones first that we're not going to be disputing. I'm not contesting that Mr. Ford has a prior felony conviction that would prohibit him from being in possession of a firearm. However, this isn't a strict liability crime where if Mr. Ford happens to be in a vehicle where there happens to be a firearm found, that is not enough, even by a probable cause determination. Some facts that I would point out to the court that I would respectfully ask the court to focus on when making its decision on bind over. Some undisputed facts. We know that this particular firearm did not come back in any way registered or proof of ownership or anything like that to Mr. Ford. Certainly the vehicle that he was in was not his. That was undisputed testimony as well. Certainly the officers that testified today don't have any personal knowledge as to who placed that firearm there, how long it was there, and so forth. And respectfully to opposing counsel, I don't see it as that Mr. Ford, assuming he did consent to this search, it wasn't because he was so confident that he had hid this so well that he was confident he could consent to the search and the firearm wouldn't have been recovered. That just doesn't really make any sense. I think it would be the other way. If someone knows they have contraband in the vehicle, I think they would be more likely to not give consent to search, not the other way around. But separate and apart from that, let's assume what they're stating is correct. They had every lawful reason to have contact with Mr. Ford because of the expired tags. And let's assume for the sake of argument, he gave valid, proper consent for them to search the vehicle. Let's see where that leads us. The testimony, and again, this was undisputed testimony, is that they did search the vehicle. The officer just testified that he went and searched through the vehicle. He looked through the vehicle, did not see anything, did not find any contraband of any kind, didn't see or smell anything in that vehicle that led him to believe that there would be contraband in that vehicle. certainly didn't see a firearm of any kind. It is only then that another officer is directed on scene, who is then directed to search the vehicle again. Now, what the people have suggested is that this is somehow one continuous search. But what I would submit, Your Honor, is if, let's assume Mr. Ford gave valid legal consent to search the vehicle, they did that, they found nothing. I think that's where that consent and that search ends. Because if what they are saying is true, then does that mean the police can then direct a second officer to come in who may have some more specialized training to search a vehicle more thoroughly? Let's say he doesn't find anything. Does that mean they can direct a third person to come and to say, well, maybe he can find something that the first two didn't. And if he didn't find something, maybe we can have a fourth one that comes, and maybe they'll find something that the first 1, 2, or 3 did. So I don't see how that is one continuous search. Those are two separate things. And my contention is, Your Honor, is that once they search that vehicle and they find nothing, then I believe that that consent and that particular search is ended. So I would ask the court to consider that and to consider suppressing the firearm based upon that. But I would also ask that the court find that there is not probable cause based upon the other factors that I mentioned in my argument as well. Thank you.
I think there's just 3 quick points I would make in rebuttal. I thought it was interesting that Mr. Austin essentially said that, well, a guilty person would say, no, you can't search my car. It's interesting for a defense attorney to say not giving consent is consciousness of guilt. I don't think that's the position he would take if there was no consent and then a gun was found. Second thing is I would just caution the court against engaging in the slippery slope argument that Mr. Austin has submitted. I think if the court was presented with a case in which they kept bringing in more and more and more officers to look again and again and again, that's a different issue. In this case, we had 2 officers took a look, and then a 3rd officer who was already en route arrived and they said, hey, how about you take a look? And, this isn't a case where they said, well, he didn't find anything. Let's try again. Let's try again. Let's try again. Now, I think the last thing I would know, I think, well, one, he's driving the car and there's a gun in the car. That right there suggests knowledge that there's a gun in the car. And I do think that I would put emphasis on the fact that Officer Vanderwerf testified to him, and he demonstrated needing to turn all the way around to look back. He described him doing that, I believe, 8 times, and that he had a lack of interest in the search whenever they were looking anywhere except the place where the gun was found. I do think that at least to a probable cause standard demonstrates knowledge of the fact that the gun was hidden back. Thank you.
Thank you. Today was a date scheduled for preliminary examination for procuring concealed weapon possession by felon of firearm and felony firearm second half. The burden is on the prosecutor to establish sufficient probable cause that these felonies were committed. That's just more than mere suspicion. This is not a matter where they need to demonstrate beyond a reasonable doubt your guilt. So it's just a very low burden of proof at this time. And then the court will also weigh any credibility issues and the people's likelihood of success if this matter were to proceed to a trial. We have here again testimony first from is it Detective Sergeant or Sergeant Patrick Mullen. He testified that on or about the 26th of February 2023 that he responded to a call at the area of North Walnut and Maple, that he had there was a request made to him of Officer Vanderwerf to assist in searching the vehicle on the scene. To his knowledge, he said that there was already consent to search given at the search that the vehicle had previously been searched by another officer there, and they were requesting that he do a search. He said during the search, he opened an area or a compartment in the left of the steering wheel, so in between the driver's door and the steering wheel, and he located a handgun, that being a Taurus with black slide loaded with 11 9mm rounds. We check of the weapon brought back no records, and that it was determined that the defendant or the person he identified as the first defendant was the driver of the vehicle. See, we had a testimony then from Officer Zachariah Vanderwerf. He testified that he was in the area of North Washington at or near Cesar Chavez when he noticed a silver Chevy Impala take a turn, and that he determined based on the way the vehicle was operating that that vehicle was seemingly attempting to avoid the officer. He followed the vehicle, noted that the vehicle, this vehicle went down a dead end and came back out. He noticed the vehicle had expired tags. The tags haven't expired May of 2022, this being February of 2023. He stated that he didn't see the defendant exit the car, but that when he stopped the defendant and asked the defendant, was he operating or in the car, the defendant voluntarily admitted that he was the one operating the vehicle and that he had expired plates. He asked for the defendant about if he had a license. He said his license was not valid. And those were two of the reasons why he was seemingly evading the officer. Officer Vanderwerf states that the defendant or the person he identified as the defendant gave consent to search the vehicle. He searched the vehicle. He didn't see anything. However, he found it concerning that while attempting to search the driver's compartment of the vehicle, that the defendant appeared to make or to be very concerned about that area and turned around, I think, a series of at least 5 times at that point. And so they radioed to another officer to assist. And Officer Vanderwerf testified that radioed specifically for Officer Mullen to come because apparently he must search vehicles better than other people. We all have our gifts. That must be one of his. And so Officer Mullen searched, or Detective Sergeant Mullen is searching the vehicle. And again, he said he noticed that whenever the search moved over to the driver's side compartment of the vehicle, that the defendant paid special attention to see what was going on that side. And that at this point he had turned around maybe 8 times. He even described that it almost how the defendant had to go out of his way to position himself or turn his body all the way around to see what was going on in the driver's side. So the defense is arguing that that there should be no the ability to search this vehicle multiple times under this consent that was purportedly given by the defendant. And that if the defendant were guilty, he would not have given consent. So this vehicle obviously not having been registered to the defendant, the firearm shouldn't be presumed to be his. If I were to take the defense's statement that a guilty person wouldn't give consent, that could be reasonable. Or I could also consider the prosecution's argument, which is that maybe the person thought that they hid the contraband so well that it wouldn't have been discovered. How many vehicles do we have that have compartments on the driver's side that we could slide a firearm or any other item in there? But what is contradictory to the defense's statement that a guilty person wouldn't give consent is that we have a person guilty of evading the officers admit that I was evading the officers because I knew my tags were expired. We also have a person who's allegedly operating a vehicle with expired plates and no license admit, yeah, I was the one operating the vehicle, yet I don't have a driver's license. If you're going to admit all that, why would I think that you would draw the line at any other things that you had the right to remain silent on? You gave all that information up. Why not let them search the vehicle? But for the fact that you believe either that they already at this point have enough to search the vehicle, or B, that you believe that you hid the weapon well enough so that they wouldn't likely find it. So I do believe that there was valid consent to search. Whether or not there was that consent extended throughout the course of this ordeal, and contrary to what Mr. Austin believes, is that the consent does not allow you to call multiple officers to the scene to do a search. I would disagree. It's one continuous transaction. They searched the vehicle. They weren't able to find whatever they were looking for because maybe that's just not their gift. They don't search that well. So let me radio someone who is talented in searching. At any point in time, Mr. Ford has the opportunity to revoke his express consent. The same way you express consent is how you revoke the consent. I didn't say all three of you all can search my vehicle, or never mind, I changed my mind. Can't search the vehicle anymore. I think that the body language or the interaction could have caused or would have caused any reasonably trained officer to think that something's going on the driver's side of this vehicle, because every time we're over here, he's looking. He's not caring when we're on the other parts of the vehicle. So I think his behavior, if in fact what they say is true, was what caused them to believe we need to get someone who can search a little bit better because something's going on and maybe there's a trap door or something we don't know about. So no, I do believe that you can have a continuous search, same as if we were to need to call out a canine to sniff the car now because maybe we can't figure out what's going on. He gave consent, didn't revoke the consent. And so the ability to calling another officer while you're on the scene with this person lawfully detained and having granted consent so that they can do a more thorough search, I think is within the realms of the law. With that being said, I believe that we have sufficient probable cause as to count one, carrying a concealed weapon, because there's at least a question of fact as to whether or not the firearm that was placed there, that the defendant knew that it was there. And there's a question of fact of whether he took part in keeping the pistol there. Maybe he did, maybe he didn't. Maybe it was the person who owned or the vehicle was registered to. We'll let the jury figure that out. And then as it relates to count two, possession by felon firearm, we have a People's Exhibit 1, which is a certified judgment of sentence, making the basis of the testimony and the allegation of count 2 sufficient as it relates to probable cause of count 2 and count 3 felony firearm. A second habitual will be bound over by bill of date for the complaint as pled will be July 1st. The circuit court's going to receive the file on July 1st. It's not a court date for you, okay, Mr. Ford? Your next court date will be a pre-trial. Your attorney will be made aware of that date. Do you have any questions at this?
I have nothing additional on
No
behalf of
questions?
Mr. Ford.
I didn't really get a good clear here at the end of it. You said, which ones were being bonded over?
All
three, okay.
all three are being bound over as pled because there's at least a question of fact as to some of the elements.
No, I just didn't hear.
Yes, but no problem. My voice is a little low, but that's because I've been sitting on the bench nonstop since 9 o'clock. So that could be flushed out at jury if this makes it to a jury trial. So all counts as alleged in your complaint will be bound over. Do you have any other questions today, sir?
No, you said July 1st.
July 1st is the date the circuit court is going to receive the district court file, not a court date for you. They will let your attorney know when your next court date is, okay? What is your phone number?
517-862-1204.
And your home address.
1020 1.5 East Oakland Avenue, Lansing, Michigan, 48906.
Okay, let's see. Bond was set. Was it enter bond? Alright, I'm sorry. Looks like it was $8,000 cash shorty that will continue. Any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
Thank you. I mean, it's 1:30 on the dot. We're just sliding right into that next docket.
Yeah, I mean, I don't want to brag, but
Just saying, I was just giving them, set a little precedent on how to do some PCCs.
She cared that much about you when she went out with your book. When she went out with it, she didn't go out with it. She went out of town. They only had one room, two buddy, and they were drinking and having fun.
Okay, are you ready on Alice King? Okay. Tree. Good, how are you?
Hello.
Didn't see the Miss Allen.
No.
Have a good one. Have a good weekend. Like, what are you doing in your house that you gotta walk around them? Like, why are you walking around so much? What is happening?
I'm sorry, Your Honor, how are you spelling Ms. Kane's last name?
CAIN.
He's a dog, A-N.
Kane. C is a cat. AIN. Alice Kane.
Yes. I found it. Thank you.
No worries. This is the state of Michigan versus Alice Kane, 2600649.
Ross Martinez from people.
Assistant Public Defender John Lee on behalf of Alice Marie Kane.
Okay. Kane was scheduled today for sentencing. Guilty to the retail fraud second, back on April 10th. There is no pre-sentence report because I advised one was not needed because she has 84 days credit at this time. And there was already, I believe, an agreement for her to pay restitution to Meyer in the amount of $182.20. So that will be the order of the court. The court will credit her time served, 84 days. And order restitution in the amount of $182.20. I'll waive discretionary fines and costs. However, I do have to assess the $75 crime victim rights fee plus $50 state minimum cost. So Ms. Kane, are you being held on something?
Ma'am?
Do you have any other cases pending right now?
No, I don't.
Okay, what are you being held in court on?
Say it again.
What's happening? Is it Antonia Martin?
Oh. Can you hear me?
I can hear you. I hope you can hear me.
I can.
Why are you smoking marijuana in the middle of my courtroom?
There wasn't no marijuana.
Put it back up to the screen. No, put what you had in your hand before.
This is what I had. You see it smoking?
Oh, okay, put it out.
Hold on, man.
You're in the middle of court.
I wasn't in court.
No,
I wasn't
you are
talking to
in court.
nobody.
You are, it doesn't matter if you're talking, you're in my virtual courtroom, or you can appear in person. The other thing is adjust your camera so that we don't have to see up under your gown or whatever you have going on. Okay? And when you're appearing virtually, you treat it just like you are in person. Otherwise, you don't get the option of appearing via Zoom anymore. Do you understand that?
Yes.
Thank you. Okay. Ms. Kane, what are you being held on? Ms. Kane?
What am I being held on?
Yeah, why are you in jail? Is it just this matter?
It was a refund case, retail fraud.
I'm assuming she's only being held on this.
Yeah, that's my house,
I don't know why I'm in here so long.
Okay, when are you gonna pay your restitution?
As soon as I get out, ma'am. I got money, I got to go to the bank to get I have to get my bank card, go to the bank and get the money. I may not can pay it all at once, but I can, cause I got 2 other restitutions to pay.
Okay, well, you need to come up and make a payment plan if you can't pay it all. I'll note that you'll pay this within 30 days, okay?
Yes, ma'am, will do.
If you need an extension, you have to come up and make a request for that, okay?
Yes, ma'am, I will do.
You're all set, thank you.
Thank you.
You're welcome.
I can leave.
You are free to go.
Thank you. Oh, thank you, Jesus. Wait, wait.
What a long, short week it's been.
For real.
Okay, Holstein, who's representing Holstein?
I'm hosting.
No, I said who's representing, but I don't see your attorney yet. Unfortunately, so we have to wait for Ms. Robinson. Okay, and then that's all we have on my docket, and then we have Buchanan's docket. You're representing Antonisha Martin,
Yes, Your Honor.
State of Michigan versus Antonisha Martin, 26-14887. Appearance, please.
Good afternoon, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Assistant Public Defender John Lee appearing on behalf of Antonisha Denise Martin.
Okay, Ms. Martin has attempted to resist obstruct an officer and a retail fraud cab second. This is a probable cause conference that was scheduled before Judge Buchanan. There's an examination scheduled before Judge Buchanan on June 26th at 9 a.m. Are you continuing to examine?
No, we are not, Your Honor. We have made a plea deal with the prosecutor whereby they will dismiss resisting and obstructing, and Ms. Martin will plead guilty to the retail fraud third.
Judge, if I may, can I just confirm with you briefly, because I show count 1 is resisting obstructing police, count 2 is retail fraud third. I thought you said attempt RNO and retail fraud second.
And it could be right. You could be right. The problem is the clerk's office writes stuff on there and they could have did the wrong thing. It should be assisting, resisting, obstructing. You're correct.
Okay, sorry. I
just read what was written there. Okay.
Got it. Thank you, Judge.
Okay. So the offer is to plead guilty to the retail fraud third and dismiss count 1.
That's correct, Judge.
So you'll treat next week as a plea and she can take her plea before Judge Buchanan in person.
Yes, Your Honor. Thank you.
Did you hear that, Ms. Martin? You have to unmute.
Okay.
Okay, you have an offer. You can appear in person next week before Judge Buchanan on the 26th at 9 a.m. to take your plea, okay?
Let me write that down. You said what date?
It's going to be on the 26th, which is next Thursday.
Next Thursday?
Next Friday. It's next Friday.
The 26th at what time?
June 26th at 9 a.m.
Okay, thank you.
Okay, do you have any
Is that
questions
all?
today? That's
I'll
all
talk
you
to-
have.
Is my attorney gonna be my same attorney?
Yes,
I'll talk to him. Thank you.
you're welcome. You're all set. Is
Goodbye.
Carl Mendenhall here? No Mendenhall?
I do not see him.
Okay, I'll issue a bench warrant.
Since the bench warrant's being issued and next week is the preliminary exam, can we treat next week? Well, do we just wait till he's picked up and then set court dates after he's picked up?
Correct. If they appear, it'll be treated as a PCC,
Understood. Thank you, Your Honor.
so you don't need witnesses.
Thank you.
Kayla Tarosky here.
Because I'm gonna be the prosecutor on that case. I know that Mr. Silverthorne had sent her various calls and emails. I'm not sure that she will be here today. I don't know how long Your Honor wants to wait.
I'm done waiting. It's
Always clear.
bench warrant. 15 minutes, but 16
Yeah,
minutes.
I'm all ready for
Issue a
that.
bench warrant. Huh?
All right, great.
If she appears next week, it'll be treated as PCC.
Thank you, Your Honor. Appreciate it.
No problem. Someone, there's no one over sitting next to Buchanan's courtroom though, correct?
Let me.
Well, yeah.
Kelly's here.
Huh?
I don't think Kelly's here, but Dave.
David.
Well, y'all sitting in another room. They might all be over there. Mr. Pfeiffer,
Hi.
welcome to court.
Huh?
Welcome 54A.
No, it's been a while. I finally have my vertical numbers down to the point where I can take on new cases again.
Look at you, showing off.
His numbers.
Said all he had was somebody else doing
I know.
this.
I have
Who did
guys
you
on the
send over?
Who did you
second
send over in Zoom?
I guess we're really doing this. Right, they too.
Yeah, bring them in here.
No, a couple pieces. One's for.
Oh, we took care of her.
Okay, we took care of it. So you don't have anybody else, so nobody's in the hallway. If you do have somebody, in the hallway, please send it to us. But right now, what's it look like?
Very good. Bench warrant. Okay, and then Ditz is in custody, Silverthorne's client. Let's see if he takes care of that. Is that the one that needs to be arraigned? Yeah. And then they're gonna put Ashley Shade on. I suppose. And then we need to know where Robinson is.
John Lee said he would text her.
Mr. Silverthorne. You had a 1:30, Kayla Churosky.
Yes.
Have you had contact with her?
No, I noted a lot of attempts, when I first got the case with Mr. Roski, repeated attempts. I was able to leave a message, but was never returned.
Oh, sounds good. And then Robin Holstein, she was here. Did somebody grab her?
She's just in the hallway. I was talking to her.
Okay.
I'm handling this for Miss Lancy.
Okay, well, she's been here for some time, so are we ready to handle her?
Yes, Your Honor. I would, just came from, I've been here all morning myself, as Your Honor has, as have you, and I just got out of Judge Ward's courtroom for her morning docket.
Yeah, I'm just wondering if we can, Miss Holstein has been here for a couple of exams, sitting here waiting, so.
Oh, okay.
Yeah, that's why I said if we can get her done, I know you want to
Sure.
talk to someone, then you can go talk to them.
That's fine.
And then I think that this person that they're putting in jail is probably your client.
Mr. Delps is one of my clients.
Yeah, all yep, there you go. All the rest of them are gonna be yours. So if we can get her take, because I don't know if you spoke to him.
He's just keeping me on. He's right there. If we want to do it right now.
You're ready on his matter?
Yes, yes.
Can you have Ms. Holstein come in here, please?
Yes.
This is the state of Michigan versus Brandon Diltz, 26-01520 FY. Appearance.
Good afternoon, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Dwayne Sullivan, the Office of Public Defender, on behalf of Brandon Diltz, who I see is sitting in a cell there at the jail.
Okay, Mr. Diltz was scheduled for a preliminary examination next week before Judge Buchanan for assault with a deadly weapon or dangerous weapon, felonious assault. Is this continuing to exam?
It is, Your Honor.
Yes, Your Honor, it is.
Was there an offer?
There is no offer at this time.
So we'll see him in person next week, or Judge Buchanan will see him next week. Again, at 9:30 in the morning on Friday, the 26th. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Nothing from the defendant. Thank you, Your Honor.
You're all set, Mr. Diltz. Okay, Ms. Holstein is here. State of Michigan versus Robin Holstein in 26-00166.
Ross Martin on behalf of the people. And I would note, we do have a crime victim present who would like to address the court when the time comes.
Good afternoon, Your Honor. Dwayne Sullivan, on behalf of the Office of Public Defender, and I'm filling in for Melanie Wanji. And this is for Robin Renee Holstein, who is standing to my right.
We have Ms. Robinson as the attorney.
That could be right.
Oh, okay.
Robinson.
Oh, okay, very good. Okay, today was the date set for sentencing. I do have a pre-sentence report that was prepared on the 15th. Did they get that to you, Mr. Silverthorne? Did they get that to you, the pre-sentence report?
Yes, yes, it was in file, and I have it, Your Honor.
Any need to make corrections, updates, or deletions?
I don't believe so, Your Honor.
You can make allocation.
Yes, Your Honor. Basically, we'd ask that the court follow the recommendation. Anything that I can tell the court, I will probably pay Ellen. First, I understand that the alleged victim is here today and wishes to address the court, and it could probably enlighten the court more than I could. But we are asking that the court follow the recommendation.
And Your Honor, there are two things. One is I would note that it's no longer an alleged victim. She did plead guilty. And I think that I would just draw the court's attention to the fact that this is her fourth assaulted conviction and her second conviction of aggravated assault. At this point, I do believe the crime victim would like to address the court.
They can do so at this time.
Do I stand here?
You can come up so that the recorder can hear your statement, sir. Okay, if you can state your first and last name and then spell them.
Arnon Tierling, ARNON, Tierling, TERLING.
Thank you. What did you want to share?
I just want to say that we've been together almost 5 years. We're trying to build a future together. finally got an apartment here in Lansing. I'm a veteran, so I was at Holy Cross for 7 months, getting transitional housing. I got a voucher. And I'm gonna retire early at 62. So we're gonna have double income. We have a real future together. This no contact order is a real, monkey wrench, flying the ointment. It's been a struggle. My sister had to help me pay rent. And, and it's not like she got away with it scot-free. Look, she's in here in court. She's been in jail. Like, enough's enough. Like,
Enough's enough for who?
Huh?
Enough is enough for who?
For us.
We didn't do this. Enough's enough. You telling her enough is enough?
No, I'm saying the oppression of the court system.
The oppression of the court system?
Yes.
We didn't commit any assaults here.
Well, I didn't want any of this.
It's not about that. You can't, society can't allow people assaulting and hurting people. That's not allowed. And this is not her first assault. She has a history of assaultive action. If her actions land her in jail, you can't now decide that it was the court system that oppressed her. The court system didn't oppress her. She oppressed herself. I don't care if she's available to help you with your rent or not. You cannot come in here and make it our fault that she's in jail.
Well, I wanted to talk to him first because I don't want to come up here. And mess
You
things
can
up.
talk to him whenever you want. This is the time for sentencing. And if you want to give a victim impact statement so that you can share with me how this case has impacted your life, you're able to do that. But what I will not allow you to do is distort what the purpose of the judicial system is. This system is not in place to oppress anybody. And in this particular case, it has not oppressed her. If she served jail time on something that she's already admitted to, it was because she did it. And I think she got a plea deal at that. She had more than one charge. But if she served jail time, that was on her own actions. It wasn't because the court decided we were going to pick on her and oppress her.
The last thing I want to do is upset you.
I'm not upset.
That's why I wanted to talk to him first.
I'm not upset.
Okay, thank you.
Your Honor, since my name has been invoked, or at least I've been referred to, I need to reply. Had I spoken with you, Mr. Tierling, I would tell you that I cannot counsel you or advise you as to what to tell the court. I've done this for over 40 years, and I'm very strict about that. I am not going to be tampering with a witness. I would have listened to you.
Okay.
Been respectful.
Okay.
And told you that you need to tell the court whatever you feel without any advice or counseling or direction from me.
Okay.
Just so you know.
It's interesting.
Anything else you would like to share, sir?
I just want to beg for mercy to get this no contact order removed.
We also have a bond violation here today. You know, bond violation is a contempt of court order. You know that?
I'm not sure what you're saying.
She's also scheduled today to address a violation of court order that she was not to have contact directly or indirectly with you or to be within 2,000 feet of wherever you were. And there was a police report filed that states that she was in violation of that and in violation of the order not to have alcohol. How are we addressing that?
Me?
Counsel?
Are you going to admit it?
Yes, I admit that.
You're going to admit to the violations? Let me raise your right, have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, yes.
Okay. And you understand you have the right to have a contested hearing on these violations that you both were in consumption of alcohol and that you violated the no contact order of the court by having contact directly with Mr. Tierling. Yes. Okay. Is anyone threatening you to waive your hearing and plead guilty to the violations?
No.
Any promises in exchange for you pleading guilty?
No.
And are you pleading guilty to those violations because you believe you are guilty?
Yes.
As to the violation that you had consumption of alcohol and that you were present with Mr. Teerling on or about May 8th, 2026 at approximately 2,200 hours, how do you plead?
Guilty.
Factual basis.
Can I say something?
Yeah,
I'm also through the other court that I received a charge from and admitted that, and I'm sentenced for that. I'm on probation for that, and I have been put on a scram alcohol monitoring system on my person.
He's talking, what other, I don't know what other thing you're talking about. You had a
Regular GPS.
No, what other court case are you talking about?
What is it, Mason.
Okay, so you have a case in Mason.
It's over
for-
with now. I'm on probation for that.
Okay, what is the case for?
That was for assault for this police officer. Not assault, excuse me, it was resisting arrest.
On May 8th?
Last year.
No.
April, yes, in Virginia court.
This is from May 8th, 2026.
This is for this court, ma'am. It's 54th and 55th. I've been, this is the second case I have.
You just told me, I'm addressing a violation.
Okay.
That you.
I violated in that county, in Mason, and I served 5 days. I was.
What does that have to do with this May 8th, 2026 violation?
That has nothing to do with that, but I'm still, the GPS was on all the entire year and a half, and I was, since then, I've exchanged that for the program on the scram. So I'm just saying, so the GPS, I just wanted to let you know, you would acknowledge that I didn't need it on, they were taken off here last few other times. But I just want to let you know that I am on the scram device and I'm been successful.
You've been on scram since when?
Excuse me, since the 8th of June.
The 8th of June, okay,
Yes.
so this was 30 days before then.
Okay, I realize that, sorry.
So
I just wanted to explain to you that I no longer consume the alcohol, but I do plead guilty.
Okay. And then what about the violation that you were present or within 2,000 feet of Arnon Teerling on that date?
I plead guilty to that.
Okay, what did you do to make you in violation of that?
We were trying to work things out. I reached out with a last desperate attempt to try to make our relationship work.
And you knew that you had a bond condition that violated you from doing or prohibited you from doing that?
I do that now. I do know
You
now.
you mean now, you didn't know that then?
I was confused. I had a lot of things going on, but
What part was you confused about?
that we wanted to be together. I just wanted to be with.
What part of the court order was you confused about?
Actually wasn't then. I'm sorry. I apologize. I take that statement back.
I'll accept your plea to the violation. That's fine. Your plea to be freely, voluntarily and intelligently made. The other concern that the court has, and sorry, unless you have another statement, you can have a seat. The other concern that the court has is that the PSI denotes that she has current bond bench warrants. This was on the 15th, so unless she's taking care of those within the last 3 days, says she has a bench warrant of the 62A District Court and a bench warrant in the 63rd District Court.
My probation officer is aware of that in Mason. She
Right.
told me that she was.
We're all aware of it here.
Oh, I'm just saying, I was just told that through that court.
Oh, you didn't know?
I that's in Kent County and I reside here now. I did know that, I believe. Yes, I'm not gonna acknowledge that I won't say that I don't. No.
Okay, what are you gonna do about it?
I have to take care of it once I'm off of probation for this county, excuse me, for Mason County. Take care of it as soon as possible.
Yeah, not once you're off probation.
No, well, I'll take care of it as soon as possible. I haven't left the city of Lansing at all. I don't have transportation, so I'm just saying. I would like to take care of it. I just haven't been able to. I'm trying to establish a homestead for myself since I haven't been able to return home and just try to stay sober as I can, follow the rules. I made a mistake and I'm working my butt off to correct it, accepting the responsibility of it. I'm also working with mental health. Initially, we were trying to get into the mental health court for myself.
I remember
Lack of
that.
communication, I believe, might been in and out of trouble myself. And so now I'm currently seeing a psychiatrist there. I have a therapist there.
At community mental health?
Yes, ma'am. And I
Very
also
good.
have medication and I have a case manager. I see once a week.
Okay, very good. What else are you doing?
I just started this regimen about the weekend. So just continuing that.
So you started a regimen for the weekend?
Just for the medication.
Oh, okay.
Psych meds.
Got it. And then are you in any treatment for alcohol?
I'm on a SCRAM program and I'm wearing the SCRAM tether type deal. So I know I'm not in any alcohol programs right now, but that is a deterrent, a total deterrent for myself. That may say something.
You need to have treatment.
Okay.
You ran a scram tether is for them to monitor the alcohol.
I agree with that.
But you need some tools.
I'm not
to help you.
indulging. I
Yeah,
agree.
to help you.
I agree.
So that alcohol is not an issue, even when the tether's not there.
I agree.
You understand that?
Yes.
Mr. Silverman?
Note that I asked the court to file the recommendation. One of the recommendations was 12-month probation, and I think that clearly would be good that she maintains the hold by the way of the form of probation. I would also note that the court gets a lot of cases of this nature. We get a lot of cases of this nature. One of the most difficult things to do. Had she been my client, I would have taken pains to let her know that the no contact order to a layperson thinks, that, well, if the person that's the protected person doesn't care, then it's no big deal. And I always make pains to let them know that the court uses it as a direct affront to the court's order. It is a disrespect to the court. It is a thumbing the nose at the court's order, irrespective of what the victim or alleged victim states. They have really no part in that. And it's for the protection of that person, because particularly in domestic relations situations. I don't know if that discussion was ever had with Ms. Holston. I would have had it. And I think it's clearly both she and her significant other, who's the victim in this case, probably would be nice if someone could communicate that to the victim sometimes too, because although they're not under the jurisdiction of the court, it would be good to advise them, because as the court can see, there is a participatory element in these cases. Thank you.
So the victim wants me to take the position that enough is enough. The thief was the one who called the police on you at the time of the violation. The no contact order will stay in place. If you think that law enforcement in the court wants to continuously deal with domestic violence situations, we do not. I don't care how your rent is getting paid. What's more concerning, what I do care about, is the fact that you were a victim of a knife being thrown at you, and you were then stabbed by the person you were allegedly in a relationship with. That's what I'm concerned about. And she's pled guilty to that. This is not her first time pleading guilty to an assault or even aggravated assault. So she's got some self-reflection and some self-work she needs to do. She's not in a position to be in a relationship with anybody but herself right now. She's not in a position to move forward in a future together with anybody but herself. She's got to work on her mental health. She's got to work on her sobriety. She's got to work on her self-control. She's not a good partner for anyone right now but herself. And so it's not a position of the court to go ahead and grant release of a no contact order just so that your money can flow better because it's two incomes. Just so that we can end up along the lines with another assaultive action on the court. Something worse could happen. And that's not healthy. That's not okay. Maybe after she gets the help she needs and she's in a healthier state, maybe she'd be better a person to be in a relationship with, and the court can consider that, but the court can't consider that today. So the no contact order will be in place during the term of probation. I'm going to adopt the recommendation of probation. There is a 12-month term of probation that will be ordered. And you have the following conditions while you're on probation. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance. How long are you on scram tether?
For a year, I believe.
Okay, while on probation, you are required to submit to random preliminary breath testing and or urinalysis testing as directed, and you have to pay the cost of that. I am noting that I'm not going to require you to do alcohol testing while you are on a scram tether, but I do want random drug testing, okay? There are no bars or nightclubs allowed for you while you're on probation. Do you understand that?
Yes, I understand.
There's no assaultive or threatening behavior while you are on probation. Do you understand that?
Yes, I understand.
I'm continuing the no contact order between you and our non-tierling. You cannot have contact with him. I don't care if he calls you. I don't care if your son is staying at his house and your son wants you to come by and see him. If your son's staying at his house, you tell your son, I can't come over there. This is a no contact order. You understand that?
Yes, I do.
Okay. There is no reconciliation during this time. There's only prayer for one another. That's all you can do. There's only love from afar. You understand that? And if he truly loves you, he'll be there waiting for you when you get healthy. You understand that? Okay. And so you are going to participate in outpatient substance abuse treatment. You're not employed, but I believe that, are you on Social Security?
Yes, I am.
You're going to maintain your treatment with community mental health.
Yes. They also have therapy groups and different groups for even substances.
Okay, you need to provide evidence that you are maintaining your mental health treatment and counseling and your relationship with your psychologist, and you will sign any necessary releases with probation, okay?
Okay. I have the information with me right now, so.
Very good. There's a $30 per month oversight fee that you're responsible for each month of probation. $75 crime victim rights fee plus $50 state minimum cost. I am going to waive discretionary fines and costs. So 12 months of probation is $360. Plus your statutory fines and costs will make it $485 total for your cost, and you'll make monthly payments on that. So that's about $40 a month, okay? Okay. Do you have any questions at this time?
No.
We're jumping with probation before you leave.
I will.
And you'll be reporting to them, or you have the ability to report to them remotely each month, okay?
Thank you.
Any additional matters for the record?
Nothing from the people.
Nothing from the defendant. Thank you, Your Honor.
A creditor time served on the violation. You have to-
No, I'm just waiting.
Yeah, okay, we'll get her down to court. Oh, that's hers.
Mr. Sorry, I tried to catch Mr. Lee. Because his showed that was Mr. Lee's guy.
Mr. Mendenhall. Treatments we get.
That's what I have to do.
Who's Mr. Mendenhall? Mr. Mendenhall, why were you late?
No, I have to ask for him to do that.
I can hear you.
Why were you late?
I got a ride from Howell and it was late getting there because I'm in the, well, I was in the farm district, place that I had never been before.
Have you spoken to your attorney?
No, I didn't know.
Ever? Ever? Never spoken?
No, I didn't know who was representing me. I believe his name.
Mr. Lee was here, he left. We noted that you were late. I don't know if I signed the bench warrant yet, but I issued a bench warrant. I'll note here that you appeared late, but they're gonna treat next week like a probable cause conference. You need to appear in person and on time, okay? And then, we'll send a message or email to Mr. Lee. What is your phone number?
My phone number is 517-882-5574.
What's that phone number?
It doesn't work yet. I'm about to get it turned on today.
What is the number?
It doesn't work yet. I'm about to get it turned on today.
There's no phone number attached. You're just gonna go get a new number.
Yeah, it doesn't work anymore. It hasn't worked in about 6 months and I'm going to get a number today.
Okay, because your attorney has tried to contact you.
Oh, that's somebody else's phone.
Well, that's why.
That's not this phone.
Yeah, but you see what the problem is.
Yeah, I didn't have a working phone.
You're giving your attorney someone else's phone number, and then they can't get in contact with you. How are they supposed to meet with you to go over your evidence? You see the problem, okay? So you have a responsibility to notify the court and your attorney of any numbers that you have that we can get in contact with you. And if you're not with a working phone, you could have given an email, or you could have made efforts to contact him yourself.
I did call the other day. I spoke with my other attorney, Luke Goodrich, 2 days prior to.
He's not on this one.
No, ma'am, he's not. But I did make an attempt to reach him, and he has my number where I live with my mother. I only went out to Howell because my dog was out there and I hadn't seen him for a couple days.
I don't
know
care
you
what you're
care,
doing
I'm
now. I just care that your attorney can meet with you
Yeah.
to help you prepare for your defense. And so Mr. Goodrich is gonna make sure Mr. Lee know that you were here.
Okay.
However, we're still gonna note that next week can be treated as a probable cause conference that gives you all time to meet with each other and go over discovery, and then set a new date if necessary for a preliminary examination. Okay? You're all set for today.
I apologize.
You're fine. But also you should note that your date is actually before Judge Buchanan. So when you come next week, you'll go to the other courtroom straight down the hallway, okay? Okay, you're all set.
What's the date?
It's the 26th
Okay, 26.
at 9 a.m.
9 a.m.
Yes,
Thank you.
you're welcome. I didn't sign a warrant, correct?
Correct.
No.
Yeah,
Okay. He's supposed to.
Did you
Allow me. Mr. Goodrich, Mr. Alani is on Zoom.
Just want to say that's a lot.
It's a classic Mr. Silverman.
Was he supposed to be here in person because of his PA 53?
No.
So, Your Honor, he got released under the old stuff, so I don't know if he would have ever.
I don't think he was been arraigned on.
Oh,
violation.
Yeah, he needs to be arraigned on the violation.
today. I think the court knows what my request is going to be.
On the record in the matter of the people of the state of Michigan versus Abu Alami, 26-01527, appearance, please.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Alami, who is appearing over Zoom today.
Mr. Alami, can you hear us?
Yes, ma'am. Yes, Your Honor.
Okay, you are here today for a probable cause conference, which is scheduled before Judge Buchanan for an unlawful imprisonment, an assault with intent to do great bodily harm, less than murder or by strangulation, and a domestic violence habitual third offense notice. That matter is scheduled for a preliminary examination before Judge Buchanan on June 26th at 10 o'clock in the morning in person at the court. You do, however, also have a bond violation that I need to arraign you on. It says here that on the complaint of violation for conditional release, that the defendant violated his bond conditions by having direct or indirect contact with a Jatila Knox on or about June 6, 2026, during various hours. The report also gives a summary of jail calls and text now messages that were recorded at the time that you were in jail and alleged to demonstrate a violation or a series of violations of the court order. You have the right to have a contested hearing on those violations. You have the right to be represented by your attorney at the time of that contested hearing. A bond violation is a contempt of court order, and so contempt of court is punishable by a maximum penalty of 93 days in jail per violation. Do you understand that?
Yes, Your Honor.
Okay. How are we proceeding?
Your Honor, today's the probable cause conference, and there are a couple things that need to be addressed on the P53. First being him being arraigned on the P53 violations. The people are requesting he be remanded. I know that he's appearing on Zoom. I'm not going to make any statements as to why he's on Zoom, but I believe that a remand is appropriate given the extensive blatant violations that were documented by the detective, where he's telling the victim, this is really terrible, I'm going to cry, I'm going to die in prison. The only way is if they dismiss it if you don't show up. I just really hope they dismiss it if you don't show up. Talk to the judges, talk to the prosecutor or something. I don't know. But God, if I get out of here, I will make it up to you. He's shaking his head, but they're recorded conversations. I will make it up to you. I'll do anything that you want once I get out of here. That's over a litany of messages and recorded phone calls. I think a remand is appropriate and necessary pending the preliminary examination and a P53 hearing, given those extensive contacts. Now that brings me to the other point, because I don't want to be seen as hiding anything here. Detective Wilson, who will be testifying to the P53 examinations, is not going to be available next week as she is handling a child crime case, a trial that's over at the 30th Circuit Court, basically all of next week with Judge Stokes. And so any testimony from her would need to be on a separate date, either with a full adjournment or a continuance. I've mentioned that to the defense, and they're asking for us to just figure out a date next week, which I don't have any problem with that. But given that I'm requesting a remand here pending that hearing, and that hearing might have to be delayed because the detective is in a trial, I want to make that abundantly clear from the jump. There is no offer in this case. The people have agreed to offer to waive the examination, and we will not add the witness interference charges that if we run the exam, we will absolutely be adding. But any decision on that is not going to be happening until next week.
Okay, thank you, Your Honor. Your Honor, we are requesting the matter be left on for exam next week. In regard to the alleged bond violation, we would just ask that a hearing be set in that matter at the same time as the preliminary exam next week. I would ask the court to consider that the allegations here are from, I believe, June 8th. Mr. Alami posted a $25,000 cash or surety bond with Heather on June 10th. Since that time, to my knowledge, there are no allegations. of any type of violation since he's been released. The allegations actually go to a time when he was incarcerated. I would ask the court to just continue bond on this matter until there could be a hearing and a determination as to whether that's him on the calls or whatever evidence that the prosecutor has. So we were just asking the court, leave the matter set and we'll have Judge Buchanan or whoever judge is handling the matter next week, resolve it at that time.
Thank you. Okay, so I see here that the alleged date of offense being June 7th. The affidavit of probable cause indicates that the alleged victim reported to Sparrow in response to assault, GPH, and unlawful imprisonment. She also indicated allegedly that there's been a substantial history of domestic violence between her and Mr. Alami, with him being the aggressor and having been allegedly over 20 prior unreported assaults. I now have an investigative supplemental report from June 9th while the defendant was in custody and after the defendant would have been arraigned by Magistrate Milmore and told that he couldn't have contact directly or indirectly with the protected party, not to be within 2,000 feet of wherever she is. And in addition to that, after having been advised that these calls were recorded, that there are a litany of jail calls. Shall I read them for us? Mr. Alami?
That's up to you, Your Honor.
Would you like me to read them so that you know what's being alleged?
Yes, Your Honor, yes, please.
Okay.
Okay, Your Honor, before you do that, I just would like to state, Mr. Alami, I'm advising you not to make comments regarding the truth or non-truth or any of the statements at this time, okay?
Yeah, yes, sir, yes, sir.
Okay, jail call, June 8th, 2026 at 2200 hours, which would have been after the time in which the defendant was arraigned, just after the time he was arraigned. Inmate tells female to take a text now number. She says she just put money on her phone and can't make a text now right now. Inmate says, all BS aside, tell me what you're doing. Female says, I don't know, I'm not going. Inmate says, they're trying to hit me with 4 felonies. I know I effed up. I'm sorry, please. I know I effed up. I swear to God, I know I effed up. I don't know why the F I do the SHIT I do, but real SHIT, bro, I don't know. I just let the anger take over. Please, just forgive me. That's all I'm asking. I know I effed up. I'm so sorry. Female asks if he can hear her. Inmate replies, Female says, I'm not going. Inmate continues, I'm sorry, I swear to God, I just don't know why the FUCK I get like that. I am really sorry though. I'm just saying that because I'm not just saying that because I'm in here. I just get upset. I don't know, bro. I know damn well the consequences. Inmate says, I really don't blame you if you don't want to talk to me. He says he still wants to talk to her and we could do what we do, like go door dashing. I still want to be able to do that. I don't know, bro. This SHIT is just getting toxic. It's getting deep. Inmate says he's been told if the state wants to pick it up, they could. Female says she is not going to go. He says even if she doesn't, he is getting fried and going to do years. Another female talks in the background briefly, but it is unclear what she is talking to the female about. The inmate says if there is any way female can find something out for him. Female says she was already talking and she was like, you don't have to show up. And if the victim doesn't show up, most of the time they, air quotes, drop it. She says something or someone at the hospital was talking to her about it. Inmate says, please, I swear to God, if they convict me for this SHIT, I'm going to go do a couple of years, even though I was just trying like do stuff. I didn't even know I got 2 felonies on my record. Inmate says his SHIT is hot right now and he is told inmate is looking at some time. Inmate says, baby, please don't send me up there. I'm begging, please don't send me up there, inaudible. I swear to God, I'll never do this SHIT to you. Like, just give me one more chance, baby, please. I swear to God, I'll never do this SHIT again. Female says, I didn't want you to go to jail. I didn't call the police. I really didn't. Inmate says, I swear to God, I'll make it up to you. When I get out this BITCH, whatever the F you want, please let me make it up. Please don't send me away. You don't know what it's like to be in this BITCH. I swear to God, I won't that SHIT again. Please find some way. Just get this SHIT gone, bro. It's 4 felonies. This SHIT ain't even like a little misdemeanor. This SHIT 4 FUCKING felonies, bro. Like this SHIT mother FUCKERs gonna try to smack me with some SHIT. Do you want me to continue? Because I'm still on the first day.
No, no, Your Honor, I understand.
Oh, okay. Your bond is revoked. You need to report to Ingham County Jail within 24 hours.
Could I say something, Your Honor?
Feel free. Absolutely.
It's just,
Mr. Alami, please be very careful. Do not say anything that's going to damage your case. Okay?
yes,
Do
sir.
not make any admissions.
Yes, sir. It's just, is there any chance, like, cause I have a job and I have my son to take care of, and it's just he needs a lot of things right now, like, and I just been trying to make some money for him just so I could take care of him, cause just the day he barely had any diapers, and then the mother, she kept asking me for help, so I'm just trying to. Is there any way, like, any way you can just do what my lawyer said, like, any chance, please? I just need, like, I got a lot of stuff,
You
like, I'm
don't have
trying
to
to.
do what the court says, but I have to do what your lawyer says. Bond
No,
revoked. You can address your bond with Judge Buchanan, but I'm revoking your bond due to multiple alleged bond violations when a recorded number under your inmate number and possible witness tampering. What you should be advised could be the potential for more charges.
You said there's potential for more charges. Like, what do you mean?
Yeah, witness tampering, it could bring you more charges. You need to be in jail by 2 p.m. tomorrow.
Yes, Your Honor, I hear you.
So you better go buy those diapers. Any additional matters for the record?
Not on behalf of the people, Your Honor.
No, Your Honor, thank you.
You're all set.
I'll listen to the other ones, I'll send them your way, so you know what's happening.
I have a lot. I've listened to a lot.
From the lockup ones?
Not the lot.
That's what I mean, but those.
So just from the ICJ.
Yeah.
Am I all good to exit, Your Honor?
Excuse me?
Am I all good to exit out of this video chat?
Yep, you're all set for today. You're all set for today.
All right, thank you.
Okay, you got it. Can you hear me? Oh, I can see.
Can you hear us?
Okay, we hear you. I just wanted to make sure I had it right.
Thank you.
That's Miss Shay.
Did you need to speak to her?
Thank you.
Yes,
You must be
I'm sorry.
warm.
I didn't get it. Pardon?
You gotta go log in to be speaker, you're saying?
Yes, I didn't think they would get it.
What do you mean?
I didn't think that the MDOC would get, she just got transported.
Oh, no, we already sent it right to WHB. They confirmed it, so.
I want to scoot just a little bit closer because I don't know, it's kind of blurry the hearing.
It may have involved. And maybe not need to log on to it.
Yeah, your attorney's gonna log in just a moment, okay?
Thank you.
Get up. Why is it not?
On the record in the matter of the state of Michigan versus Ashley Shade 26-01301. Appearance.
Good afternoon, Your Honor. Jennifer Lawton on behalf of the people.
Good afternoon, Your Honor. Dwayne Silverthorne. I'm from the Office of Public Defender on behalf of Ashley Shade, who's appearing on screen from, I think, the Women's Correctional Facility in Ypsilanti.
Women's Huron Valley.
Huron Valley.
Yes, okay. And today was the date that was scheduled for a probable cause conference before Judge Buchanan. This matter is scheduled for preliminary examination on child abuse third degree individual court on the 26th, 10 o'clock in the morning in person at the court. How are we proceeding?
You want me to go ahead?
Go ahead, Mr.
Yeah.
Silverthorne, thanks.
Procedurally, we are going to keep the preliminary examination next week, but in actuality, there has been an offer conveyed that Ms. Shade is going to accept it, wants to discuss more with me, which I understand, and have the plea in front of Judge Buchanan next week. I have also indicated to Ms. Lawton that subject to Judge Buchanan's approval, she can release her witnesses. Again, that's subject to Judge Buchanan's approval.
I am okay with that. Presuming that it is going to be a plea, the only issue that I have is if the exam were to be run next week, I would be requesting an adjournment of the exam because my officer in charge is on a pre-scheduled vacation out of state next week.
We would agree to that on the record. That's not a problem.
Okay, so officer in charge is on vacation and not available next week anyway, so we'll move forward as a plea. And if for whatever reason your client changes her mind or the plea fails, then I guess it'll be treated as a probable cause conference again, and Judge Buchanan could address the time.
Thank you, Your Honor.
Thank you.
No problem. Any additional matters for today's record?
Nothing else from the people.
Nothing else from the defendant. Thank you, Your Honor.
You're all set for today, Ms. Shade.
Thank you.
You're welcome. That's all we have.